be very open to the public. And we are going to present tonight what each one of those meetings will have. What I am going to ask my colleagues to do is we have a subdivision that we need to get off our agenda. We will handle that first. Then I'm going to request from my board members, and if they grant it, that we will move up on the agenda our discussion on the proposed zoning amendments. And then at that point in time, because people have come with the belief that they could speak, I am going to open it up for you to speak. All right? I'm going to ask you to please, this is not part of our agenda, and our agenda is packed. It is packed every month. We try to get people in and out as fast as we can, so we put a lot of stuff in. People are waiting on their homes and stuff. So we have a packed agenda tonight. So I'm going to keep you to 3 minutes, and I'm going to be pretty strict about it. So please, be concise. It does not prohibit you from coming back to the other meetings and speaking then. The other thing is, and I need to note this, that those meeting schedules have to be flexible. We'll put down each day, for each night, you'll see what we're going to try to get accomplished. If we don't get to something, obviously it will be moved to the next meeting, and we'll just move them through. And we'll get to you why we have to do this. It's governed by law. Okay? Thank you very much. That's the chair's announcements. I need a roll call and a count.
Mark Brady?
Here.
Dr. O'Neill?
Here.
Thomas Callahan?
Present.
Rupert Friday?
Here.
Stephen DeSimone?
Here.
Okay. I'd like to welcome Mr. DeSimone to the board. Mr. DeSimone, if you could, introduce yourself to everybody and keep it concise.
You got it. Stephen DeSimone. I live in Narragansett. I have for most of my life, including my childhood. I went to Narragansett. I graduated in '03. I'm a builder. I was appointed by the board, and I'm happy to be here and help.
Great.
Thank you.
Okay. Under Chairman's announcements continued, we need a secretary. First of all, I'd like to thank Jerry for his service. He was an independent person. He had no ties to anybody. He was excellent in what he did. Mr. DeSimone has big shoes to fill, and I have no doubt he'll do them well. But he was phenomenal, and he will be a loss. But he was also our secretary. So I need a motion and a second on a new secretary.
Mr. Chairman, I'd move that we appoint Rupert Friday as secretary.
Usually what we do is wait for somebody to leave the room. Mr. Friday, would you accept that?
Mr. Chair, do we have appointment of secretary on the agenda? I just wanted to bring that to your
No, we don't.
Okay.
How do we function without one? I'm thinking we got...
I would suggest a motion for a pro tem secretary
Okay.
this evening, and then we can
Thank
put
you.
it on the agenda. There's no reason why that person couldn't be the...
Eventually, but we'll have to get on the agenda.
Just, it's with it not being
Right.
posted, we don't want to run afoul of
So
open
those
meetings.
of you that have never watched us and never come, we are this is not going to be exciting, folks. We are very legal, and we are driven by the letter of the law. We follow the letter of the law. So can I ask the,
Mr. Chairman,
Mr. Callahan, would you modify your...
Can I amend my motion?
Yes, please.
So I move that we and I nominate Rupert Friday to be the secretary du jour for this meeting.
If you need a second, second it.
So, Mr. Friday, you were bypassing whether or not you were interested in doing this.
I'd like to recuse myself from this vote.
So you
I hope my wife's not watching.
Well, it's just for this evening, so would you fill the role for this evening? So I have a motion, I have a seconded it, and Mr. Friday has been politely coerced into saying yes. All those in favor?
Aye.
All those opposed? All right, thank you. Second thing on the item, and it is on the agenda, so Nick's not going to have to work too hard. We have a vacancy of the planning board. We have a representative to the Land Conservancy Trust. Jerry was our liaison. Do I have a motion for someone to serve on as a liaison between the planning board and the Conservancy Trust? And this is a big thing. It's a huge importance to this board as to trying to tie in tightly with the Conservancy Trust and what they do. Do I have a motion?
I move Mr. DeSimone to be the liaison with the land trust.
So, Mr. DeSimone, usually my tactic is just to blow past you and get a second, but apparently people are... So, are you okay with the nomination?
Yes, absolutely.
Okay, do I have a second?
Second.
All those in favor?
Right.
I think everybody. Doc did. Yep. Okay, all those in favor?
Aye.
Aye.
All those opposed? Okay, ayes have it. All right, I need a motion and hopefully a second, and to move up the item E4, which is our discussion on the proposed...
Mr. Chairman,
Yes, ma'am.
you're reading the Roman.
Oh, that's right, I got the old one. Sorry. This whole night has been in motion till about 3.5 minutes ago. Your notes are worse than mine. So which one are we? Where do you go? Where do you got it?
You want to move C
Yeah.
1 up.
No, I want to keep C1. Oh, okay. Yeah. So I need a motion to move C1 Clark Road subdivision continued, preliminary plan, major subdivision with street creation, plat 5, lot 27, up before the proposed zoning ordinance amendments, discussions, and possible actions.
So moved.
I'll second that.
All those in favor?
Aye.
Thank you. All right. So,
Mr. Chairman,
yes,
I'd like to recuse myself for this matter, please.
thank you very much. The second order today, and for those of you out there, this is no surprise. I have a great deal of respect for the people who serve on this board. I've already talked to Mr. DeSimone. Mr. DeSimone, you are new. You are, I'm going to have, by law, I have to ask you, have you reviewed all these materials? Do you feel, to the best of your ability, that you can fulfill the role of making a decision in this hearing?
I have reviewed all the materials and watched all of the YouTube sessions from this preliminary hearing, and I do think I can participate.
Okay, counsel, are you comfortable with that?
Thank you, Mr. Chairman. Michael Resnick on behalf of the applicant and the owner, and based off of Mr. DeSimone's representation to you as chair, we have no objection
Thank you.
in his participation. Thank you.
Okay, so just to explain procedure for you, the reason why we do this is subdivisions especially, but decisions before the planning board, and we make decisions, we make recommendations, but the recommendations are legal. And when people come before us, they're actually asking for an exception to the law. They're asking for a variance. They're saying, we recognize what the law is, but for whatever reasons, we need an exception to that law. And what can happen, and simply, it does from time to time, is the proponent of the project doesn't feel that we gave as much as they thought they should get, and they can appeal it. And sometimes what happens is the abutters feel that we gave too much, and they can appeal it. It is not a lawsuit. A lawsuit would be negligence on our part or failure to follow the law. It is an appeal, and it's one of those things where we try to balance everything. We hope everybody walks away comfortable, but it doesn't always happen. So I want the record to show that Mr. DeSimone stated that he is comfortable, that he has reviewed all the materials, including videos of the meetings, and that Mr. Resnick, representing the proponent, has also agreed that he is comfortable with this. On that said, Mr. Resnick, I turn the floor to you, my friend.
Actually, Mr. Chairman, if you could just ask me the ethical questions.
Oh,
at the
thank you very
offset.
much.
No
This
problem.
is something I've already
No problem.
discussed. The town council we've not had a builder before, so we're going to get a different perspective here, but it also comes with some complications. The town council had a meeting with the Ethics Commission, and we were advised that because of the nature of Mr. DeSimone's work and his dad's, that we have to ask these. And I've asked him, because I'm old and I forget, that if I forget, that he should remind me. So, Mr. DeSimone, have you had any business relationship in any way with the legal representative for this applicant?
I did employ a lawyer from their law firm on a project that we completed. I completed my work with them over 2 years ago. I haven't spoken with them since, but I did once hire that law firm.
Okay. Legal, is that a sufficient period of time so there's not a conflict of interest? Thank you. Told you this wasn't going to be exciting, folks. Have you had any business relationship in any way with the applicant themselves?
No.
All right. Have you had any business relationship with any of the applicant's consultants or support personnel?
I did hire Mr. Rabideau many years ago as well. There's not too many wetland biologists, so
Yeah.
he's a good one.
Counsel, are you comfortable with that? Thank you. Okay. Hearing that, are you okay?
Yes.
Okay, great.
That's
Record show.
absolutely accurate, and unfortunately, I was an associate, I believe, at that time, so,
Young buck.
yep, but not anymore. Anyways, thank you, Mr. Chairman.
All right. So let the record show that both towns, the planning board's counsel and the applicant are in agreement and are okay with Mr. DeSimone sitting on. So welcome. Welcome to your first hearing.
Thank you.
Thank you, Mr. Chairman. After the last hearing, there was actually an extension granted, but previous to that was the last time I was before you, and we made certain promises about items that we were going to tie up with town staff, with your engineering department, et cetera. And I know, Mr. Brady, as chairman, you were CC'd on most of these communications with the town attorney as well as the town planner. So I think that you have a fair bit of idea of the travel. So the first document I'd like to discuss is the HOA document. And what I can say is we went back and forth from that last hearing.
They don't know what HOA is.
Oh,
Oh,
of course.
yeah, good point.
I appreciate that. Thank you, Mr. O'Neill, Dr. O'Neill, rather. Homeowners Association, all right? And a homeowners association is the way in which the lot owners will share in certain obligations, which includes certain obligations under any decision that would be levied by this board, including appropriate manage and maintenance of the stormwater. So that the HOA is the feature and the mechanism that the individual lot owners can be held to their obligations by this town, by and through the board's decision. And so that's why it is a very, very important document, and there's been a lot of back and forth. And I can suggest, or I can represent to Mr. Chairman, that based off of my final discussions with town staff, through your planner, your solicitor, as well as communications that you were on, I believe that unless there is further comment by this board, that we have an agreed upon final document.
Does staff agree? Please. Can you make sure your mic is on?
You referred to that document as the homeowners association. Are you talking about the declarations and restrictions?
Yes.
That has 4 sections, one of which is the homeowners association creation. And the others are restrictions and easements.
Absolutely, yes.
Okay, thank you.
Thank you. Staff, are you good?
Yes, as Mr. Resnick said, we've been a lot of back and forth with staff.
Exhaustively.
It has been.
Yeah, and I appreciate all the back and forth. Ultimately, I think that we got a very good document as it relates to that collaboration. There is one item that
There's always one, Mike.
there is one item that I would like to request that the board allow us to reserve a potential edit to final approval, which I understand the board has an appetite to have us back for a full public hearing, should be even more appropriate. And it's Lot 2. Lot 2 is not actually served by the road, and the developer has a question of whether or not that lot owner should be required to pay for maintenance of a road that they don't utilize. At the end of the day, it's just going to change some of the percentages relative to the fee, the annual fee. It's not going to obviate any of the other obligations of the Lot 2 owner. It's solely relative to the road, and it would just be, candidly, it was brought to my attention by the town solicitor, conflict solicitor, and I thought it was a very good idea. And it was based off of the concept that there's been issues with other developments that have been approved where a lot owner says, I never drive on this, why am I paying for it? So that's the only thing that we would ask to reserve on.
If you look at the graphic up top on the southwest corner is Lot 2, okay? Counsel?
Yeah, I think that what Mr. Resnick is asking is that during the final approval hearing, which is not going to be a public hearing, but just a meeting, that he reserves the right to make a change to that document if his client wants to. When I first suggested that he might want to take a look at that issue, it was at the point where I think the documents said that the street would be private. The street is going to be a public street, so the town will be maintaining it, but there are a lot of ancillary drainage improvements that are solely related to the road, and those are on private property. And the owner of Lot 2, under the current wording of the agreement, would have to pay for maintenance of those as well. And I think that's what Mr. Resnick and his client want to discuss.
Okay. Staff, are you in concurrence?
Yes.
Okay, Mr. Resnick, you're okay if we make it a condition that that's be resolved?
Yes.
Okay.
Yeah, absolutely. We just want a little flexibility.
Yeah, okay.
So the next document, in addition.
Now, hold on. I open up to the board. Mr. DeSimo, the way we do this is, hate to do this, but we've all been at that end of the table. We go from longevity down to the rookie. So you're the rookie, and I'm a product of the United States Maritime Academy, so you're the plebes. So,
All right.
Dr. O'Neill, questions? No. No?
My question was related to what you just addressed.
Okay.
Yep, my questions were also answered by staff.
Dynamite. Okay. So, Mr. Resnick, we're going to make that a condition that that's resolved by final. Okay?
Absolutely.
Okay, thank you.
And again, thank you for the clarification. This HOA document has restrictions, declarations, covenants, important features of a land evidence
Yeah.
recording. It's not just.
And for the public, this is what goes forward after the developer. The developer does the best they can to leave things as perfect as they can, and then life takes over. So these are the documents that live on afterwards, and they're really government of the ownership, so they're key. Mr. Resnick?
So the next document that we worked on was the actual conservation easement document. I'll discuss the plan in a moment. And similarly to the aforesaid document, the HOA document that we just discussed, I believe in coordination with staff that we've come to an agreement as to a final draft of that agreement. We've accepted any changes that were presented, and I would tell you that I think the most material ones were there was some questions about how often inspections would be taking place.
Yeah, I think that was because there seemed to be two different verbiage in documents, and we were trying to get everything uniform.
Correct. So what we did was we looked at the DEM regulations, and essentially what we've agreed to with staff, and I hope it pleases the board, is we're agreeing to the most draconian testing that DEM has for any of those categories, so it's biannual. Okay. So we just simply, there was a question, how often, and we said we're going to do it the most draconian that we've done in this document, the most draconian that DEM does it. So I believe that, hopefully that satisfies the board, and that was one of the more major edits.
Okay. Counsel? You're good? Staff? Oh, go
I
ahead.
think it's been reviewed exhaustively.
I would say exhaustively would be a minor word. Staff?
Staff is all set.
Okay. Dr. O'Neill?
Yeah, I've forgotten, to who or to whom, I'm not sure about the English, do you report every 2 years?
Yeah, what was decided? I think we decided that
It's every 6 months, not
6
every 2
months.
years.
Right, every 6 months.
And
I thought
reports
biannual,
go
okay.
to DPW.
DPW. Okay.
I have a problem with the English language, so.
Me too.
But you birthed everybody
I was an
in this
English
place.
major, and I don't know what's right.
The only thing is Doc has birthed everybody in this town, so. Rupert? Steve?
I'm satisfied.
Okay. All right.
If I may move on to the.
You may.
All right, the next document is the actual conservation easement plan, which is an exhibit to the conservation easement. And I will tell the board that unfortunately I'm not joined by the engineer this evening, but what I can say is that staff received an updated revised conservation easement plan, and I'm going to say it in a lay way. The concept was to make that plan as verbatim as possible to the DEM approval. And I believe that that has been accomplished. And I did just ask Ben Cato, our engineer, to send me an email today so I could at least describe to you in his words what he did. And he said, we went through and fine-tuned the easement plan to match the revegetation areas as shown on the approved DM plans. And that's exactly what he did, and it's our position that was done appropriately.
Okay. Counsel? You're good? Staff?
Yes, we are satisfied. That copy of that plan was in your packet.
Yeah.
And its most recent date is March 12th, 2025.
Thank you. Dr. O'Neill? No. Rupert? Steve? Okay.
Just one
Anything else?
other thing I would bring to the board's attention, I know it's in your packet, is your engineering department and DPW did have the opportunity to sign off on it, and there's a memo to that effect.
Yep. Staff?
Correct.
Okay.
And I would just finally say that, obviously, the board is aware that at one time, this project was required in between master and preliminary to obtain zoning relief. So this project, as it stands before you, it's our position that through the experts, through the testimony we've presented, we meet the comprehensive plan, we meet the zoning ordinance with that relief I just referenced, we meet the regulations, we have all state permits required in hand, and we believe that the expert testimony that we provided you is not only accurate and credible, but respectfully, it has not been rebutted by any competent expert before this board. So it's our position with the conditions, and that's the final thing. There's always one final thing. With the conditions that were sent over by staff that I know were worked on by the board, I had a couple issues. It was condition 8 or 10. I'd be happy to discuss it, but I understand that internally there was some tweaks to that language. I looked at it. I'm fine with the tweaks. I think that it still captures the intent of the town, and candidly, we all have an interest in making sure this decision is legal. And those were what my comments were about. And I think with those edits, every condition we agree to, and we believe that they are legal conditions.
Terrific. Staff, you want to add anything?
No, Mr. Resnick
Everything's
is
been
covering
said.
it all.
Counsel?
Mr. Resnick has covered it all.
Okay. I'm going to open this up to a vote. Before I do, final comments. Before I do, I have to thank everyone involved in this. These are not easy. Subdivisions are complicated because there's a lot of moving parts. This one was a little bit more complicated because of the site. There are not hundreds of hours involved in this. I think there's probably close to 1,000+ hours have been put in by all sides. The dialogue has always been open. It has never been contentious. I think what we walk away with is a subdivision that is solid for the community, solid for the applicant, and probably most important, for those that are going to move in there and raise their children, it's going to be a nice place to live. And that's just my opinion, and I just wanted that on the record, and thank everyone involved, the board, council, staff, Mr. Resnick, you and your people. So thank you.
And I would echo the same sentiment, and I'd like to commend town staff and town solicitor in working with us on these very complex documents.
Thank you.
It wasn't easy. They were voracious in advocating for the town, and we were able to come to an agreement.
Right.
Thank
Don't
you.
go anywhere because they're going to have final questions. Doc, anything?
No question. No.
Rupert?
So, yeah, Mr. Resnick, I'm wondering what the most recent date of the revised plans are. I have the most recent date for the conservation easement plan, but I'm not sure about the other plans. The other plans that I had were
Council, are you listening?
October 2024.
Hold on. The Council, are you listening?
Mr. Chairman, that was my fault. I'm
No
sorry.
problem, no problem. Can you repeat those? Because,
Yeah, so wondering what the dates of the final plans for the subdivision are. I have the one for the conservation easement, but the
Actually-
others I have are October 2024.
Mr. Friday, I could answer that.
Oh, okay.
Yep. So, thank you. It is correct. It is October 22nd, 2024, with the conservation plan, which I believe is sheet number 5, at March 12th, 2025.
Okay,
yeah.
great. Thank you.
All right, Steve?
Thank you.
I'd just like to also thank the board and the staff and everyone, because after reviewing the many hours that this has been before you, and the enormous stacks of documents. I think you guys did a fantastic job coming up with a good project in a very difficult lot and area. So,
Thank
but
you.
that's all I got.
At this point in time, is there anybody from the public that would like to talk or speak on this project? Please come up, state your name, where you live.
I think Tom.
I would like to, for the record, Mr. Callahan is speaking as a private citizen and not a member of the planning board.
Want me to swear him in, Mr. Chairman?
Yes, you do.
Please raise your right hand. Do you solemnly swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please state your name and spell your last.
Thomas Callahan, Callahan,
Thank you.
406 Baltimore Avenue, Narragansett.
That's about as exciting as we get, folks. Mr. Callahan, the floor is yours.
Thank you very much, Mr. Chairman. So when we met last, I tried to make 2 points, that there were 2 findings that I was not sure you were going to be able to make. And I think Mr. Resnick and I, probably for the first and perhaps only time that we have agreed on this application, said that the staff memo that was written at that point in time suggested that the adverse environmental impact determination did not have to be made till final. I'm wondering if that is still the staff's position.
Mr. Callahan, Mr. Chairman, no, I did speak with our current legal on Mr. Callahan's concern, and we believe that, in fact, the the finding of fact should be met here at preliminary.
Okay.
So that
Decision
finding,
has been rewritten.
Can you put it, Counsel?
The decision, the draft decision has been rewritten to reflect that.
Okay.
and there has not been a revised staff report that's been forwarded to the board. Is that correct?
That is correct.
Okay, thank you. So I just want to go back over the two points that I made.
Hold on, I wanted everyone to know, even though a report didn't, we all have copies of all the most up-to-date documents, okay?
Mr. Clarification, Mr. Chairman, and I think what Mr. Callahan is asking is if, and correct me if I'm wrong, if there was a drafted decision or a revised report that went to the entire board?
Right.
And no.
No. Yes.
No, yes?
No, it hasn't, but we are all up to date on the documents.
I just
No,
want the record to be clear.
I just didn't want the impression to go out that we're going to make decisions on stuff we haven't seen. That's all. Okay?
Okay.
We've seen the materials.
So if you determine this application to be complete and in conformance with the land use provisions of our comprehensive plan, you must make 5 required findings before approving it. I don't believe you can make at least one of those findings. The proposed development still presents material adverse impacts, and let me explain why. At master plan, this board found conditionally, and I emphasize the word conditionally, that the project presented no adverse environmental impact. That finding remains conditional until you're satisfied that the conservation easement, working in tandem with the homeowners association agreement, can properly protect the site's high-quality water and wildlife resources in perpetuity. Again, in perpetuity. Although Rhode Island DEM issued this project a freshwater wetlands permit with a variance, it did not review or approve the terms and conditions of either the conservation easement or the homeowners agreement, nor did it opine on their adequacy to protect the site's wetland and wildlife resources. The documents apparently weren't even included with the applicant's RIDEM application. The determination of their adequacy is yours to make and yours only. And you must do so citing the specific evidence that leads you to conclude that the conservation's easements, terms and conditions, working in tandem with the HOA, will properly protect this site's undisputed, high-quality wetland and wildlife resources. Mr. Resnick will remind you once more, already has tonight, that Mr. Rabideau is the only qualified wetlands expert to testify before you. That's true. However, the board should assign weight to his testimony only after giving careful consideration to the following. The initial failure to identify and include amphibians in his initial wildlife assessment was highly unusual for a site comprised 44% of freshwater wetlands. The failure of any report to identify the RIDEM's designation of 2 resident amphibian species of greatest conservation concern, or address the likely impact that forest and forest canopy fragmentation would have on their critical habitat. It lacks the imprimatur of a credible, independent third-party review. All of this is not necessarily a reflection on Mr. Abadou's professionalism, rather more likely reflects scope, strategy, and resource decisions made by the applicant. Previously, I said you needed to make one additional finding, again citing specific evidence on the record, that the proposed subdivision will not create one or more individual lots with any, and I emphasize any, physical constraints to the development, so that building on those lots according to pertinent regulations and building standards would be impracticable. You may recall that I pointed out that the applicant's own engineer's construction drawings, sheets 6 and 7, made abundantly clear how wetland resources impose such severe constraints on this site that building on one or more of the lots should be considered impracticable. You may also recall that I submitted to the record email correspondence between the applicant and RIDEM staff, in which the applicant represented to RIDEM staff that it could not further modify the plans. This was email correspondence that took place in August and September. That this project has been in the planning, this is a quote, this project has been in the planning process for quite some time, and the developers have spent a lot of time and a lot of money, a lot of time and money to bring plans to this point. The developers have indicated that they will need certain requirements to make the project work, such as garages and the number of bedrooms. The layout that has been submitted meets these parameters and also allows for some flexibility for future buyers. The final footprint for each lot will be determined by the buyer and need approval from the town. Any construction will need to take place within RIDEM's approved limits of disturbance. Having said that, nevertheless, the applicant has since modified his plans, significantly shrinking the size of the house and the garage in Lot 1, further accommodating RIDEM's insistence on compliance with its limit of disturbance setback standards. I believe these accommodations likely render my prior objection as to the practicability to construct moot. If this board approves this application, it should require strict conformance with whatever conditions it establishes. Why? Throughout the proceedings, the applicant has established a pattern of failing to honor important representations and obligations. For example, at master plan, then attorney Matt Callahan, on behalf of the applicant, asserted that the homes would be occupied by year-round families and not rentals. The applicant has reneged on that commitment during preliminary. In 2023, the applicant was cited for nonconformance with the terms of its prior RIDEM permit for indiscriminately clearing within the limits of disturbance. The disturbance of additional vegetated cover inside the limits of disturbance likely had the effect of expanding the building development envelopes allowable under the 2022 regulations. Finally, the applicant failed to secure 2 Narragansett construction access location permits prior to undertaking land clearance and road construction work again in September of 2023. The principals of Clark LLC, Mr. Mink and Mr. Hurl, ultimately doing business as SkyCap, Connecticut domiciled limited liability corporation, are the developers and owners of record of 2 homes on Sylvan Drive. During the recent February 18, 2025 Town Council meeting, Mr. Durkin was engaged in Councilor Durkin was engaged in a colloquy with a citizen talking about the impact of the FAR regulations in town. He cited these homes as the proximate cause of the enactment of the town's bulk zoning regulations, saying in part, quote, "It's unfortunate that these 2 buildings were built on Sylvan Road in Scarborough. They were 8 buildings, and I feel bad for anyone who's had to live by them." I agree with Mr. Durkin. I suspect the neighbors and residents do as well. Please do all that you can to ensure that history does not repeat itself in this instance. Thank you.
Thank you, Mr. Callahan. Anybody else would like to speak on this? Mr. Russell, you would like to redirect?
Mr. Chairman, I have nothing to add.
Okay.
I believe with respect to Mr. Callahan that we've heard these issues several times. I've responded to them several times. It goes unchanged. The inescapable fact is that the only expert evidence before you speaks to the contrary of what Mr. Callahan is presenting to you. And I have to say, it is an invitation for this board to go outside of its jurisdiction. It just is. There's state statutes, there's case law. I've discussed this with the town attorney. We have gone through all this process because we want the community to understand and we want the planning board to understand. It's DM's jurisdiction and the permit was issued. And I will remind the board that Mr. Callahan had more than a lot of discourse with DM during that process. All of these issues were raised. I've seen the emails. Thank you.
Thank you. Doc? Questions, redirect?
No.
No? Rupert? Steve?
No.
Are you okay with Steve?
Yeah, that's
Okay,
fine.
thanks. Staff? Any redirect, any last you want to add? No? Council? You just want to get away from this finally. I thank you for everything you've done. We could not have gotten through here without you. Appreciate it.
You're very welcome.
Thank you. Do I have a motion?
Mr. Chairman, I have a motion.
Okay.
I move to approve the preliminary plan for the Clark.
Hold on. Oh, I'm sorry. I need a motion to close the public hearing.
So moved.
Seconded?
I'll second.
All those in favor?
Aye.
Okay, public hearing is closed.
Mr. Chairman, I have a motion. I move to approve the preliminary plan for the Clark Road Major Subdivision, Assessor's Plat V, Lot 27, with the revision 7 by Millstone Engineering LLC, most recently revised October 22nd, 2024, and the Conservation Easement Plan revised March 12, 2025, and all the supplements with the following findings of fact and conditions. Finding of fact 1, the requirement that each subdivision or land development project shall be consistent with the requirements of Narragansett Comprehensive Plan or shall satisfactorily address the issues where there may be inconsistency. The board found, as a matter of fact, during their master plan deliberations, that the subdivision proposed is consistent with Narragansett's comprehensive plan in that it is low-density area according to the future land use map, and that the layout of the property is consistent with that of a low-density neighborhood or subdivision. Furthermore, it is designed with the conservation of natural resources in mind. This finding is supported by the applicant's willingness to have a 5-lot conventional subdivision that would have a greenbelt easements as indicated in their application, and in particular the map entitled Conservation Easement Plan, Clark Road Subdivision, Assessor's Plat 5, Lot 24, Clark Road, last revised March 12, 2025. This implements the Comprehensive Plan Land Use Policy, LU 2.4, built upon the Greenbelt Network that protects dedicated open space and enhances local development. Unfortunately, the Planning Board finds the subdivision is not consistent with the Comprehensive Plan regarding the Housing Policy 4.1 to encourage year-round rentals to build a stable year-round population. The Planning Board would prefer to have a provision in the Homeowners Association agreement that limits the rental of houses by requiring any rental to have a year-long lease. The applicant's unwilling to make this a provision of the Homeowners Association agreement, and the Planning Board does not have the authority to require this condition. Finding of fact number 2, we're required to find that each lot shall conform to the standards and provisions of the Narragansett zoning ordinance. The proposed subdivision has received special use permits through Zoning Board of Review for development within the coastal and freshwater wetlands overlay district at a hearing concluded on May 18, 2020, and therefore meets this requirement. Finding number 3, there will be no significant environmental impacts from the proposed development as shown on the final plan with all the required conditions for approval. The applicant has received approval from the Zoning Board of Review for special use permits to allow construction in proximity of freshwater wetlands. As part of this approval, a critter crossing on Lot 1 shall be constructed per the approved plans. Conservation easement approved by the Planning Board will be recorded together with the final plat. The conservation easement area encompasses a substantial portion of the development. The conservation easement will protect the most environmentally sensitive areas of the site, including wetlands, vernal pools, from degradation. It will be enforceable by the town as well as by the property owners. RI Department of Environmental Management has issued a wetlands alteration permit for this development. The permit requires, among other things, the restoration of areas cleared under previous approval and imposes a stringent inspection and maintenance requirements concerning stormwater management facilities and features. Those requirements have been included in declarations and restrictions, protective covenants and easements, and creation of the Clark Road Homeowners Association document. The planning board finds that a cluster development would have been a better method of subdivision of this property because it would have resulted in commonly owned open space areas containing the most environmentally sensitive features of this site. However, the version of the land development subdivision regulations under which this application is vested do not give the planning board the authority to require cluster development. So the board finds that the subdivision meets this requirement. Requirement number 5, the subdivision as proposed will not result in the creation of individual lots with such physical constraints to development that the building on these lots, according to pertinent regulations and building standards, would be impracticable. The board finds this provision is met based on the fact that the development has received relief from the Coastal and Freshwater Wetlands Overlay District, Section 4.3 of the zoning ordinance, and relief from the planning board from Section 3C1 of the subdivision regulations, providing waivers for lots 1, 2, and 3 for land unsuitable for development. Finding number 5, that a requirement that all proposed land developments and all subdivision lots shall have adequate and permanent physical access to town or state accepted or approved streets. The proposed project will create a public right-of-way and road to be adopted by the town. The owner applicant will be required to construct the right-of-way and the road to town specifications prior to any adoption. Once adopted, this provision will be deemed to be met. Should the roadway not be adopted by the town, it is approved as a private road, and this provision will be met. The following 2 items are specific required findings set forth in Narragansett subdivision land development regulations. Number 6, each subdivision shall provide for safe and adequate local circulation of pedestrian and vehicular through traffic, for adequate surface water runoff, for suitable building sites, and for the preservation of natural, historical, cultural features that contribute to the heritage and attractiveness of the community. This requirement is met regarding circulation, building site, historical, cultural features. The project has been reviewed by the engineering department as well as by the fire marshal. At master plan, the town engineer indicated that the project needed to be reviewed for technical merits, so the proposed stormwater drainage, and the fire marshal indicated he would need to review this project again for proper hydrant location. Both tasks have been addressed and are approved by the respective departments. The conservation easement includes protection of the stone walls in the development, which preserves historic and cultural features that contribute to the heritage and attractiveness of the community. And finding number 7, the design and location of streets, building lots, utilities, drainage improvements, and other improvements in each subdivision shall be minimize flooding and soil erosion. The board finds this requirement has been met as utilities and drainage improvements, as well as the erosion control plan, have been reviewed and approved through the engineering department. The town engineer notes that each building site will require specific analysis and drainage assessment at building permit stage. There's no waivers required at the preliminary plan, and we have these conditions for the approval. Number 1, receipt of any needed special use permits or variances at the building permit stage for the development of individual lots, specifically addressing building footprint, section 7.7 drainage calculation, and any other relevant proposed altered condition. Number 2, before final plan approval, the staff will determine the fair market value per acre, the conservation area in the subdivision, and calculate the fee in lieu of the land dedicated in compliance with section 3D of the land development subdivision regulations. Staff will discuss the proposed fee with the applicant. If the applicant does not agree with the amount of the proposed fee, the applicant shall hire a professional appraiser to appraise the conservation area of the subdivision. The staff recommendation in the applicant's appraisal will be provided to the planning board, and the board will determine the amount of the fee at the final plan approval. Condition number 3, the baseline document be prepared and submitted by the applicant to the town's administrative officer for review in consultation with the Conservation Commission and legal and approval counsel prior to the final plat reading. The baseline document shall be prepared with the text, photographs, maps, and illustrations to the standards of the Land Trust Alliance Accreditation Commission or the U.S. Department of Agricultural and Natural Resource Service, and prepared by a qualified conservation biologist or similar expert with demonstrated experience preparing baseline documents for conservation easements deemed acceptable to the town. The baseline document shall be recorded in the land evidence records with the final plat. Condition 4, the edge of the area protected by the conservation easement will be marked in the field with permanent boundary markers prior to the final plat recording. Condition number 5, that the applicant provide surety of $595,346.63 in a mechanism acceptable to the town for road construction and other infrastructure improvements, which shall be submitted to the town prior to final plat recording. Condition number 6, that the applicant resubmit the roadway details for review and approval of the Public Works and Engineering Department as necessary prior to final approval. Condition number 7, that prior to recording the final plat, the applicant will develop a brief one-page information brochure that explains the conservation easement in the requirement for pervious pavements through driveways and the required monitoring and maintenance in clear language that is easily understood. This brochure must be provided to every prospective purchaser of a lot home during the initial sales meeting. And the purpose of the brochure is to ensure transparency and explain to future property owners the reasons behind the town's requirement for the conservation easement and the pervious pavement on the driveways. Condition number 8, any further subdivision of this plat and/or increase in the number of dwelling units in the plat, whether they are principal structures or accessory dwelling units, shall require RIDM review or, if applicable, RIDM approval before an application to the town for such a subdivision or increase is approved. Condition number 9, that the development will comply with all RIDM wetland permit conditions. Condition number 10, the driveway for each lot will be constructed of pervious material and shall be installed in according to the manufacturer's specifications. A registered professional engineer or registered landscape architect retained by the property owner or the town engineer or building official shall certify in writing to the administrative officer that the driveway has been correctly installed before a certificate of use and occupancy has been issued for the house. Condition number 11, that upon building permit application, drainage calculations, and design for each lot shall receive approval from engineering department regarding the requirements of section 7.7 of the zoning ordinance. Any revisions associated with specific drainage must be reviewed and approved by Community Development and Building Inspections Department for compliance with the June 18, 2020 approval from the Zoning Board. Condition number 12, that any proposed site work or landscape improvements such as driveway construction, grading, or other landscape improvements within the public right-of-way between the property line and the existing edge of the pavement are subject to review and approval of the Department of Public Works. No site work may begin until the project has been reviewed, approved, and a road construction permit is issued by DPW. In addition, a track-off pad must be installed and used for the duration on-site construction. Condition number 13, that the applicant may make a change to the HOA for the percentage fee for lot number 2, which will be resolved before final approval. And condition number 4, that the final plat review is designated for planning board review and approval.
Counsel, you good with these? Okay. Mike?
No objections to any of those conditions, and thank you for the thoughtful decision so far.
Thank you. Just for the public, so you know that, this isn't unique to Narragansett Planning Board. We're not heaping things on. These are standard. The applicant's lawyer will tell you, our staff lawyer and staff will, these are pretty universal conditions that are put on, and they're important.
Mr. Chairman, just to explain, a number of those conditions were made at the master plan stage,
Yeah.
so they're just followed.
And none of them have been a surprise. These have been ongoing throughout. Do I have a second on the motion?
Second.
All those in favor?
Aye.
All those opposed? Passes unanimously. We will see you at master.
Thank you, Mr. Chairman,
Mike.
members of the board. See you at final, and thank you to staff. Thank you very much.
Thank you, everybody. Karen, thank you beyond thanks. We appreciate it. We're going to have changing. We're going to give us a couple minutes. We have to change some things up. So, Karen, you were chatting. Thank you. You got us through this. We appreciate it. Thank you much. We hope to see you again soon. Not on something this engulfing.
I'll be back for final.
That's right.
Yeah.
Okay. Looking forward to it. I want to thank the public for your patience. We don't usually get these audiences, so you get to see the inside of what we do, and it's extremely legal. The amount of time people dedicate that are on these boards, and the thing is, it takes about a year to even understand what we're saying, and we know a lot of what we said went by you, but if I took the time to explain everything, we would be here for about 6 days, and so I apologize for that. But
Mr. Chairman, I think it might be interesting for folks in the audience to point out that the only person on the board that was on the board when this subdivision started is Dr.
O'Neill, and he was 13 at the time. It's been around for a while, but we got it. Okay, we have moved the agenda item up as far as Town Council Planning Board 14 proposed zoning amendments, discussion and possible action. As I stated, tonight is not the hearing, and I know it went out on social media. Yep, I know it went out on social media. But the fact that you took the time to come, I'm going to give people 3 minutes to speak. I would ask you to be concise. It doesn't preclude you from coming back. But understand, we are not in a position to answer. We are just in a position to listen, because this is not a formal hearing, okay? I do know that somebody on the board would like to make a motion.
Thank you, Mr. Chairman. First, for the record, we're getting, I think all of us are getting many comments,
Yeah.
emails on this proposal. And I want to thank the residents for weighing in. I've reviewed the comp plan proposed changes twice, and they're complex. They're proposing major changes to the zoning laws. They're proposing major changes to the planning review process. For us to provide the council sound, thorough, and well-considered review and advice, I think we need more than 45 days, and I think 45 days is inadequate. We need to research the impact and consequences of some of the proposals, and frankly, we need to understand what's being proposed and why it's being proposed. For example, why are parking standards being eliminated from multifamily dwellings, and why are we proposed to eliminate the special use permit for serving alcohol at existing non-conforming restaurants in a residential zone? Don't know what the idea behind that is. At the town council meeting where these were sent to us for review, the town council president Menzies asked if the council could give the planning board more time than 45 days. I move that we ask the council for a minimum of 120 days. 120 days will enable us to provide the council members with the information so they understand what's being proposed, the impact on transparency for development process, the impact on neighborhoods, the impact on the town's budget, and I make a motion to ask for the town council for a minimum of 120 days to review this package of 14 ordinance changes. This would still be more than 3 ordinance changes per month, and I think major changes like this need careful consideration. I move that.
Do I have a second?
Second.
Okay. Before I open it up to everyone for discussion, I was in contact with council. And so I sent Nick an email asking for clarification. I did a ton of research. Again, if you're on a planning board or a zoning board, you're kind of a legal junkie, so you do research. And I'm going to read into the record what I sent to him in an email, and I CC'd staff so that it was full disclosure. Nick, at tonight's meeting, it is possible that a board member may ask the board to request the Narragansett Town Council to grant the planning board more time to process 14 ordinance changes the council proposed at their last meeting. I'm trying to anticipate what we can or cannot do if this happens. Based on my understanding of state law, we have 45 days in which we must evaluate, make a recommendation, prepare a report for the town council, and return it to them, all within that 45 days. The council has 45 days to act on this recommendation. That is inaccurate. That was a misprint in the legal case, and in my discussion with Nick, he pointed that out. And subsequently, I found that in state law, that the council has 65 days in which to act on it. To further, this comes from what appears to be a precedent-setting case, that is the 45 days. Case C.A.W/C2021-0448, filed November 9th, 2022. The case was brought forward by the Narragansett 2100, represented by Jolie Roca. Is that right? Roca? Joel.
Joel
I'm sorry,
Rocha.
Joel. All right, Joel Roca. And it was brought against the Narragansett Town Council, who is represented by James Callahan, who is now the existing town council. In the decision, Judge Taft Carter was explicit, see page 5, and I quote, "Upon receipt of the proposal, the planning board must report," and must is a legal term, it doesn't say shall or may, must report their findings and recommendations to the town council within 45 days, unquote. The decision then went on to explain exactly and specify exactly what must be included as a deliverable to the town council. The decision goes on to stay at the top of page 6, and I quote, "The town council must then hold a public hearing and within 45 days, which is actually 65 days, render its decision." On section 45-24-51. Questions to council were, it is my understanding of this case is my understanding of this case and the time constraints correct? Number 2, what happens if we, the planning board, cannot get through all of the town council's proposals in the allotted time? 3, these were given to us as one lump proposal. Are we required to return them as one lump proposal? If not, must all changes still be returned within that 45-day window? 3, what happens if the town council does not render a decision on all of their proposals in the allotted time? If there are any other elements I have to consider, please address them. Thank you. Mark Brady, Chairperson, Narragansett Planning Board. This was taken up in the reality that we had only 2 planning board meetings scheduled. This one was already set. We set our agenda a month in advance. We have to, because we have to give legal notification, notify all the proponents, et cetera, so forth. So we only had one actual meeting to go forward with, and I knew that that was not enough time. So subsequently, we have scheduled 4 work sessions for the public. They are open meetings. You're all welcome. And we will present, actually, you can take a picture of that. That is our schedule. It is not concrete, folks. If we can't get to something, it's obviously going to get moved to the next meeting. At this point, Council, I'm going to turn it over to you. Is this consistent with what I sent you?
Yes, it is.
Okay, thank you. Could you address the questions?
Sure. So your recitation is consistent with our...
Did you press your button?
I did.
Okay.
Your recitation is consistent with our conversation today. The case, this isn't governed by a case. It's governed by state law. Rhode Island General Law 45-2451 outlines the procedure by which a zoning ordinance amendment is proposed and adopted. It's, to paraphrase, it's referred to the planning board. Upon referral, the planning board has 45 days to then study and make a recommendation back to the town council. At that juncture, the time clock for the town council starts. They then have to hold public hearings within 65 days. Once those public hearings have concluded, they then have 45 days to take action. By law, this is, in the intent of that law, is to have a very streamlined process. So we're on a time clock. Everybody in the room is aware of that. But the procedure or the methodology by which you folks have, whoever decided to have a number of workshops, is the appropriate way of dealing with a dense subject matter in a short period of time. So my suggestion, do your darndest to comply with state law. I know this board does that within those 45 days and report your findings back to the council.
Okay. What happens if we cannot get through all the items in the 45-day period?
There's a interesting provision in these circumstances. Same statute, if it gives the board the ability to request an extension. Interestingly enough, the state law says of the applicant. Here, the only folks or entity that I could envision being the applicant would be the town council. So under those circumstances, you may request an extension, but whether that's granted or not, I can't guarantee, of course. So again, I would try your best to be prepared to, I would use that 45 days as a hard deadline until told otherwise.
Okay. The next question is, these were given to us in one proposal. Do we need to then send it back as one proposal? And even if we broke it out in the individual ordinances, we still have to get all of those into them within the 45-day period.
My suggestion would be responsive to everything that was sent to you. the style in which you choose isn't governed by law. You can choose whether it's piecemeal or as one bundle, that's up to the board. There's no right answer there.
Okay. And if the town council doesn't act on these, we get it to them in the proper time. They don't act on them within that window. And I don't anticipate that happening. I think they will. But if they don't, do these proposals given from the town council automatically go into effect?
If the town council doesn't act, no.
Okay.
No, they're subject to a strict timeline.
Okay. All right. The other thing I asked you is if there were any other elements that I have not considered in this letter, to please address them. Is there anything I did not consider?
That's a loaded question, but
I understand,
if something
but-
comes to mind, I'll be sure to let you know.
Thank you very much.
You know that.
All right. I didn't do this to discourage the motion. I would also like to, and I would vote in favor of asking for more time. Hold on. I still got the floor here. But I do need to be responsible, and that's why I asked these questions. The other thing I would point out to this board, that not only do we do our hearings and findings, but they have to go to staff. And then staff has to put the legalities to these and then get it to the council within 45 days. So we don't have 45 days. We have to get it to the staff with enough time for them to do their due diligence and get this in legal format, reviewed by council, and then back to the council, the town legal council review, and then get it to the town council. Based on those, the town council does not have a meeting in the time period that we need in order to get guaranteed an extension. Again, I'm not saying this to discourage it, and I will vote in favor of asking for an extension. But understand, we cannot legally, morally, ethically, and professionally sit and wait for a decision because the clock will be gone, okay? So I pass on this, the floor to Dr. O'Neill.
Yeah, I just want to ask counsel here. So we have 14 issues to discuss, and we have 45 days to discuss it. So my understanding of the 45 days is if there's an issue that has to be resolved, reconsidered, reconstructed, or whatever, I understand why that time period is. But the number 14 is the problem. What if it was 24 or 54? Is there no reasonable, whoever constructed that rule and regulation of 45 days, doesn't that apply to a single request?
Right, it's a good question, and I don't know when the General Assembly crafted that legislation, whether they contemplated one item at a time, or 10, or 20, or 100. But what I can tell you is the statute doesn't speak to the amount. It doesn't say if there's 10 amendments before you would give you extra time. So it's very likely that wasn't contemplated at the time, but we must follow the law, and it doesn't provide a detour or an alternative avenue with the volume that is before this board.
And if we say we can't do it in that time frame?
My recommendation is to follow the law.
No, you're missing the point.
He's got your point.
What, you say follow the law, yeah, usually I do. But sometimes there are unreasonable requests, and they have to be, I don't know, confronted or denied. So if we are unable to fulfill this for the 14 and 45 days, is the town council by law then able to act without our recommendations, without our considerations?
Good question. Mr. Brady was kind enough to talk to me earlier today, and that came to mind. That's something I'd have to research, frankly. I told him when we spoke earlier that I didn't have an answer in the moment, and that was shortly before this meeting. Good question, but nonetheless, I think you do your best to fulfill your role.
Yeah, we certainly would like to cooperate and do what's reasonable, but I think, the number 14 and 45 days is like, whoa, you got to be kidding, right?
So we had that conversation. He's going to research. I do have something, I'm sorry to steal this, but a point of information. 45 days, are those 45 business days or calendar days? I meant to ask you that today.
It's calendar days, unless it's
It is
business
calendar days.
days,
That's, I assumed, based
No,
on what I
sure.
researched,
Yeah.
it seemed like 45 days. So we don't actually have 45 days. So, thank you.
So can we ask for a 15% modification?
Tom?
So it's 31 days.
It is.
It's 31 days, is that correct?
Is that if that's the math, it's I'll
It's
defer,
31
I'll defer
days
you, Mr. Callahan.
from today. Can you tell me, the state's requirements, are they codified here in town under 21.1?
State's requirements as
For the planning board review of a proposed amendment to the zoning ordinance?
whether they're codified or not, state law would trump. So
I guess there's been a discussion for a while now that there are some places where the town's requirements seem to be at variance with the state's. And I'm trying to figure out if what's in our zoning, what's in the zoning ordinance, what's in our municipal ordinances reflects the state or has something in addition to it.
if it doesn't reflect the state, that's a problem, and state law would trump. I don't have the ordinance in front of me, but certainly state law would trump in control.
Would control, but the town does have discretion, yes?
In what regard?
Home rule, if we have the ability to add something to what would be required? Or are you telling me that if whatever's in here, so for example, there are 5 things that I understand each one of these 4, we'd have to make a finding on for each one of these 14 things. Whether the amendment is consistent with the aims and the principles embodied in the ordinance, whether the amendment is consistent with the town's comprehensive plan, how and where the amendment will affect the town's land uses, buildings, and facilities, how and where the amendment will affect the town's natural and water resources, and whether or not the amendment will affect other regulations. So that's, I guess what I'm asking you is, do you know whether that's consistent with state law or not?
It is. It
Okay.
is, and that's,
All right.
that's
So-
your task.
So just so we have a sense of what the, it's not only the number of things that are, but in order to do the proper due diligence on this and to give it the, I would assume what the council would like from the planning board is its best thought about each of these amendments. And understanding that we have at least 5 things that we have to do for each one of these things, and making judgments about how things are going to, how each of these things are going to affect things like natural land and resources and land uses and it's not a simple task. I'm not, it's not a simple task. Having said that, some of these things are harder than others. There are a couple of counselors here tonight. I'm sure they'll, they have the opportunity to speak when they have an opportunity to speak tonight. It was my understanding, having watched the tail of the tape of the night that this was presented, is while Councilor Vignali and Councilor Colonies sponsored it, it was a unanimous vote. But in making a unanimous vote, there were several councilors who qualified their statements by saying, I'm not sure I'm on board with all of these. I need to see what happens with all of these. I would simply say to the council, if you're not sure you're on board with some of these things, perhaps you might prioritize by focusing on those things that are where you have clear consensus that you all want to see have done. Continue to discuss amongst yourselves whether or not you've got consensus for the rest, and send them and perhaps modify the motion that you made. We will do what we need to do in the meantime, but I would ask you to review the sections 21.1, remember what you're asking us to do. I presume you're doing it in good faith and you want us to do a good job, and then determine whether or not you've done what you wanted to do.
Steve, give me a half a second because I want to clarify something, because there could be a misunderstanding here. This board has come under fire from people who have stated we do things illegally and that we break the law and that we're sued constantly. And I don't want Mr. Callahan's comments about us doing things inconsistent with the state. The 45 days is not what he was asking about. He was asking about the 5 items that we have to address when reviewing every one of these. And what he's asking about is something that this country is founded on. We wouldn't have been formed without it, where the federal government granted states the right to an enabling right for them to enact laws that they thought maybe weren't exact fits to them, but allowed them to strengthen the laws and make it work positively for their communities. And that was, Enabling Act was passed down to cities and towns. While council would, and I didn't brief him on this, so I'm not going to put you on the spot, but I think he would concur from me, and I've done this all across the country. I've been in all 50 states before, planning boards and zoning boards. I've served on planning boards and zoning boards in 13 different states, and it is consistent. Enabling acts are carried out two fundamental guiding principles. One, you do not weaken the law, and two, you stay within the intent of the law. And I think council would concur with that, those are driving, there are other things, but those are the driving things. So those 5 items were put in under the enabling laws, and those are the 5 items that we are legally bound to, even though the state may or may not say we have to. But Mr. Callahan was not looking for a loophole on the 45 days. We know what the state law is, it's consistent with our laws, and we have 45 days in which to address this, and 45 working days. We actually don't have 45 days, so 31. Thank you very much, 31. Okay, Steve, thank you very much for your patience.
No problem at all. So I do have a couple of questions. I'm sure that we'll all work diligently and staff will work diligently to do everything we can to come in the next 31 days. That being said, I wouldn't object to requesting some kind of extension. I do have a question. You're going to have to give me a little grace here. I'm not a lawyer, as my father likes to remind me, and getting my head around Clark and the other issues, I've only read these twice now. It seems to me several of them only bring us into conformance with state law. I'm not sure if that's correct, and I don't know how many of them are that. So I was wondering if
I'm going to interject, Steve, and not to cut you off, but the motion on the floor is the 45 days. So the intent is this, because we're not in an open hearing. I don't want us to be in a legal quagmire here. Okay. So we're just addressing things that would impact the 45 days. So if you could keep that, and I respect where you're coming from.
Absolutely.
And we're going to have plenty of time to do that. Okay.
It is pertinent to the 45 days, because if 6 or 7 or 8 of these are simply to bring us in conformance with state law that supersedes us anyway, those should be quick items. Now, I don't know if that's true. That's why I'm asking. It seemed to me that some of them were.
Yeah, some of them are, others are not. Others are more discretionary, where opinion or subjective opinion comes into play.
All right, and do you know the number, the breakdown? Like I said, I only read them
them
twice. I'm sorry.
But certainly when they're discussed, whether it be at the work session or what have you, they'll be taken up one by one, and that's where that'll be crystal clear.
Okay, thank you for the
Thank you.
clarification.
And I didn't introduce myself, Mr. I'll talk to you after. Nice to meet you.
Thank you, Steve. Tom?
I'll just make one more practical observation. Is 14 from 31 is 17. That will be the next time the town council meets to review any requests that we get. And so we will, in the meantime, will have had 2 meetings on this, maybe 3. So we'll be down the road, but I'll just make, even if we ask the town council, unless they would take this matter up in a special meeting, which I consider would be highly unlikely, we were actually talking about 17 days.
So, Mr. Chairman, if I could interject here.
Yeah.
Just a couple of different things. First off, is the motion an additional 120 days on top of the 45? I'd like to point out that the 45-day deadline, the clock started ticking on March 3rd. The deadline is actually April 17th. The next town council meeting is April 7th. So by the time you even find out it's on the agenda or get a positive vote to continue the time frame, your report will be written. You have 4 meetings, special meetings covered, where the staff intends to complete everything and have a report written for you prior to or on April 9th.
Rupert, are you asking for 120 days on top of the 45 or inclusive of the 4? Total?
I was thinking total.
Okay.
Then then I would like to remind this board as well that you have 2 open public hearings
Yeah, I was gonna go
with
through
2
the
other
count.
zoning ordinances occurring and 2 more in the hopper. That's 18 separate documents. In each one of these amendments, as you know, because you've been through, and for anyone in the audience or at home, each one of these amendments, of these 14 amendments, includes several sections, and they cross-reference, and there are threads that run through. So it's very complicated when you have 18 ordinances coming through. So my point being with that is if you continue it to the April meeting or the May meeting, I want to remind you that you already have open public hearings happening in April and May.
Yep, I was going to bring that up. That's on my list of things, and one of those is the state law changes, which we know what we've gone through the last couple of years. That's huge. That's going to take more than one meeting. So, but again, didn't bring this up to thwart a proposal. I'm going to vote in favor of it. I just would recommend highly, and I think council will back me, we have to get this done in the 45-day period, regardless. Okay? All right. Doc, redirect on this?
You don't want to hear comment.
Rupert? Tom?
I'm good.
Okay. Steve?
I'm also good.
Staff?
Can we confirm when that 120 days additional that you're asking for, the date that would be?
It would be 120 days from the day that it was sent
From
to us.
March 3rd?
Yeah, that's what I'm proposing.
Could I?
I think that would have been the responsibility of the person who proposed it.
Could I change my mind on whether I could add something else on that?
Yeah, yeah.
You know,
That will give him time to figure out
Yeah.
what the 120 days are. So start counting,
I'm
buddy.
probably going to confuse him a little bit more, though. 120 sounds long to me, just seems long. 90 seems better, for whatever reasons. 90 seems like a better number to me than 120. And it recognizes, I think, both the urgency in which we're being asked to move, but recognizes as well the need for some thought and analysis, comparable thought and analysis to go into this. So I don't know, Rupert, if you consider an amendment to your motion of 90 days, but I'd take that.
Okay, and I'll address that and I agree. I'm not looking to stretch this out. I'm looking to do it right. We have 4 public hearings, okay, and all the work that leads up to those public hearings. All right, and people, tonight what we had was a public hearing, so you get the gist of work involved in that. We have the summer coming, which means vacations. People are not going to be here. So these are some of the concerns I have, okay? But that said, whatever the board decides to go forward with, I will support. You got your shoes off?
So the motion is for a 90-day, is the request.
I
of
don't know.
council-
He has not made an amendment to his proposal.
I agree to that amendment.
Okay.
Yeah.
Staff, does that give you enough breathing room, 90 days? Seems tight.
That's tight.
Staff is willing to have it done in the 45-day timeframe.
We have to have it done. This is just elementary. We have to have it done in 45. Council has told us. So,
90 days just protracts the situation, and we, as I mentioned, you already have 2 open public hearings.
yep, we actually have 4. So.
You can certainly ask for the time extension, but by the time you get an
Yeah.
answer on that, your 4 special meetings will be over.
Yeah, I've already put that forward, and you have to have the report into them within the 45 days. So, what do you got per date?
Around, I don't have this. I
We don't
have
do
it counted.
rounds. This is legal.
I
Give
don't
me a
have it
date.
counted exactly.
Then just choose a date.
It would be, let's say, June 2nd.
Okay, so is that your proposal?
That's my proposal.
All right, so the proposal is to request an extension from the town council till June 2nd for us to get the report to them.
You need a second?
No, I need a discussion on this. This is procedure, my friend. Doc, anything?
No.
Nope. Rupert? Tom? Steve? Council? Staff?
I'm just trying to figure out what day of the week, June 2nd?
Yeah, I was going to ask you, when's our meeting during June? And I'd prefer to push it to that. I mean, at least give us some breathing room there.
That would be more than the 90
Is-
days, so our meeting would be June 17.
Okay. So we'll
I'm
just,
sorry, your meeting would be June,
The planning board meeting would be June 17.
so rather than days, why don't we talk about a time period? Sure. And go June 17th, or June 20th, the end of that week. That gives us time to discuss at our meeting, get it back to staff, and they can do the work. So what's that Friday?
That's Friday, June 20th.
Friday, June 20th.
So I amend my proposal to
All right.
request for an extension from the
All
town
right.
council to Friday, June 20th.
So, and I apologize to everybody for this. This is sort of like hot dogs. You don't want to see how they're made, but we're doing this on the fly right now. All right. Doc, any questions or concerns, issues, complaints?
So you have a motion on the floor?
Motion is
Where are
floor
you?
is to request an extension
to the-
until
to the
June
council.
20th of the council.
So you need a second.
Second.
You got it.
Okay. Any comments you want to add to that motion, Doc? No. Rupert? Tom? Okay. Steve?
I'll just say, it seems staff wants us to get it done in 45, but never hurts to ask.
Yep. The reality is, it is indeed just staff. The law requires us to. We have to have this done in 45. All those in favor?
Aye.
All those opposed? Okay, it passes unanimously. Okay, this is not an open hearing on this. I'm going to bend the rules as chair, and I went through Robert's Rules of Order, and I have the authority to do that. I know some of you came thinking this was a hearing, and those are the hearing dates. I would encourage you to take pictures. And if other people are confused as to when they are, I would encourage you to get that information out to them. Again, this is our best guess. All right, if something can't be reached on the 24th, it will get moved to the 25th. But we will have them done by the 3rd. We have no choice. This is 40 years of regulations being undone in 31 days. So you will do it. We will do it. It's been requested by the council, and we will get it to them. And we will do as best a job we can to make sure it's consistent with the master plan, state and local regulations, and land use. So that said, I don't have a list of people, so if we can just be respectful of each other, I'm going to put you on a time for 3 minutes, folks, and I'm sorry, but I got to keep you on it. So anybody want to step up? We'll go from the front and work our way back. Young lady, you want to go first?
Nice of you to call me young.
Can you put that microphone on, please? It's just press the button and the red light will come on.
Yes. Is that
There
on?
you go. All
Hi,
right,
my
if-
name is Sue Bush,
And can you tell us where you live so we know you're from Narragansett?
65 Robinson Street.
Thank you.
And I'm concerned with overdevelopment in this town, and I have been for a very long time. Went through a very vocal period. Didn't feel like I was heard very well, so I went away, but it looks like I have to come out of hiding again. One of the topics that is of concern to me that I saw in an email was the perhaps raising from 35 feet to 40 feet, the height of a building. I don't see that listed here. I'm not sure if that would fall.
It comes
under-
under bulk
It would
regulations.
be under the bulk?
Yep.
Okay. And I just would like to say, once you build, you never get that land back. And what makes Narragansett special is, I think, the open space we have, the green space that we have, and it's a downward spiral when we start bending and changing these rules. Thank you.
Thank you.
Nope, there's a guy behind the podium, you can't see him.
Gentlemen, sir, does this gentleman want? No? Sir, behind you?
Thank you, Mr. Chairman.
My pleasure.
My name is Joseph Franchina. I'm in the Briggs Farm area. I live at 6 Lauderdale Drive. My wife and I moved here over 20 years ago, and there were issues with the URI students and so on and so forth through that period of time. It got better, and now, thankfully, we have a semblance of order, and that's in the Briggs Farm area. I can't imagine what goes on and eastward look. But this is a critical issue. I can't imagine how you can possibly examine all those ordinances in that time period. It just seems like you're being pressured. I'm very concerned. Our town is changing, and we have investors coming in from out of town to purchase land and to make a lot of money here, and that's what's happening. And I was hoping our town council would help us protect our town from that, but they don't seem to want to do that. And after seeing what's coming out now, I can see that that's the case. So the buck has to stop here. Planning and zoning has to do something to protect those of us who live here full-time. It's changing the complexion of this town. This town is not a cash cow afforded to some landlords, many outsiders, to make a lot of money. That's not what we're here for. That's not what this town is here for. And we have to be very careful, else we'll destroy the town. We'll never have young people, young families moving in because the price of houses and everything else will climb. And it'll continue to climb because of it. Because there's a lot of money to be made here. And that's not why we moved to Narragansett, because there's a lot of money to be made here. It was a good place to live. So be very careful. I ask you to really restrict what's happening from the town council. They're not here to protect us any longer. Thank you very much.
Thank you.
Mr. Chairman?
Yep.
Yeah. Can you clarify something?
Yes.
Can you clarify something that this gentleman brought up?
I was about to.
Oh, were you? Okay. We are an advisory body.
Yeah, I was going to do the same thing.
We don't make the rules. The council makes the rules. We are advising them. Remember that. I've been around a long time, and people will come up to me and say, why did you guys? We don't make the rules. This is an advisory body. That's the sadness of what you just said. So many times people don't understand that. The council makes the rules. We don't make the rules.
Yeah, I was going to add to that. I think people don't understand the role of the planning board. We are an advisory role. We're an advisory role to two parties. One is the town council. They can ask us, which in this case they have, and it's within their scope, to give our recommendations to these. And it will go back, and then they will make the final decision. We can actually send stuff to them. Since I've taken over as chair, I've sent forward 3 affordable housing initiatives to the town council, and that was generated here. Some of it was in conjunction with the affordable housing group, but that came from us to the town council. We also are an advisory board to the Zoning Board of Appeals. They are the legal body that make the final decisions. We are not, okay? We work with the proponents to get through some issues and try to create a balance for them and for the community. We try to save both the town and them legal costs and money, and I believe we do in the end by scoping and shaping developments and proposals that are solid for both the town and the individuals. So understand, we do not make decisions per se. We are an advisory group, and both the town council and the zoning board take our recommendations along with, I'm sure, other recommendations and their own decisions and values into these decisions. So please understand that. Also understand, because we are getting deluged, thank you very much, and I don't mean that sarcastically, I do appreciate, we are getting deluged in the last couple of days with emails. I understand our emails have been posted, and understand we cannot legally respond to any of them, okay? We can't even say, hi, how are you, thank you. So we are getting them, we read them, but we cannot respond to them, okay? Thank you. All right. I'm going to stay on this side of the road, and anybody else over on this side? Young lady?
I understand.
Relax, we don't bite.
Okay, I know.
If you can tell us your name and where you live.
My name is Dina D'Uso. I'm a resident in Narragansett. I know that you can't make any suggestions such as that you just said. I just wanted on record that I think that the town council has disrespected this board, has disrespected the residents, disrespected past town councils who have made these ordinances to try to help the town to be a place to live, grow a family. And again, I feel for you, and I hope you get the job done and some sleep also.
Not much of that
So
lately.
again, it's just for the record that this town council has disrespected everyone in this town and previous town councils. Thank you.
Anybody else on this side of the room? Some folks? No? All right, I'm going to go to this side of the room. Anybody else here? Folks, ladies before gentlemen? Sorry, I have an Italian mother, so strict rules there. Again, if you can state your name and your address so we know if you're from Narragansett.
Yeah, good evening. Gail Scowcroft, 19 Prospect Avenue. First of all, I want to say I'm really sorry that this has been dumped on you guys. I think it speaks to the inexperience and incredible ignorance of the town council to dump 14 ordinance amendments on you like this. It's also disrespectful to the staff. The previous speaker didn't mention that. You are a volunteer body in this town. You're serving all of us by your service, and it's extremely disheartening that this has happened. And I have to ask myself, is this truly due to the inexperience and ignorance of the council, or is there some other agenda at play? We have a council of 5 people that were elected due to the support of Narragansett 2100. It is no secret. All the residents are thoroughly aware of it. And what is before you for consideration are zoning ordinances that in some cases took years to pull together across councils. We had a town council president speak at the last meeting and try to advise the current council not to put this forward. We had 2 other councilmen, one councilman and a councilwoman also tried to provide this guidance, and it wasn't heeded. So what's before you, I agree with the first speaker, this is really a serious situation. The residents are paying attention. Note all the emails that you guys have received. And, you know, I wish you the best. Again, I'm just so very sorry that this is happening for all of us.
Thank you. Next? Yes, sir.
Good evening, Harry Schofield, 9 Atlantic. You know, I'm here tonight. I want to speak on behalf of the Narragansett Town Residents Association. But I also want to tell you that I've been, as many of you know, I know many of you, a resident here for nearly 50 years. And this is the most outrageous proposal I've seen any town council make to you. I have great respect for what you do. I know you're advisory. I know exactly what you do and what you're ruled by. And I respect the work you do and always have. And it's obvious that we have a new town council. And with the exception of one member of that council who has conflict of interest everywhere, the rest of the members are new to governing and clearly have no background in planning and zoning. And so it's hard to believe, it's impossible to believe that a redlining of the zoning ordinances to the degree that was sent to you wasn't done by solicitors and legal people with special interests in mind. It's obvious. So I have great respect for the situation you face. You're doing a good job at addressing it. I wouldn't want to be sitting where you are. And to think that any one of these things took longer than 45 days and even 90 days, and everyone in this room knows that. So this is special interests speaking through naive, inexperienced new council members who are doing the bidding for others. There's no other reasonable explanation for what's going on here. So I'm here to call a spade a spade. That's what this is. I wish you the best. Do the best you can. The bulk zoning ordinance alone. What really is upsetting and underlying this to me is we're largely a built-out town. You all know better than most people in this town the water and sewer marginalities this town has and has had for years and have never been properly addressed. And so now when people come along and start ripping up bulk zoning ordinances, right, and you start wanting to push duplexes on marginal lots, you just spent an hour earlier tonight discussing wetland issues of a new development. Well, think about the ramifications of all of these changes across a whole town that's largely built out and has water and sewer problems to begin with. So I just want to say this is clearly a new council where a couple of members are being used by special interests. There's no other reasonable conclusion. And yeah, the residents, they're going to hear about it. People are going to complain about this. You know, Gail is right. The previous speaker is right. This town's future is at stake. You know, I've raised kids here. I now have grandchildren in the school system. This issue is abhorrent to anyone who really lives here and cares about the long-term future. Thank you.
Thank you. So I'm going to go back to this side. Anybody else? Anybody interested? Sir, please. Again, state your name and your address so we know you're from Narragansett.
Hi, my name's Kevin McKenna, 31 Pleasant Avenue, Narragansett. My heart goes out to you people tonight. I feel that it is unreasonable to expect this planning board to change 14 amendments within such a short period of time. It's unreasonable and crazy, and it's not fair to you. That said, I oppose these 14 amendments because what they're going to do is gut our current zoning code. These changes were introduced with no public input and will devastate our current zoning code. This is a drastic change in our zoning that will affect all town residents. The town council should have held a work session to explain these 14 changes and the rationale behind them before just trying to push these changes through with little or no resident input. Approximately 75% of the town's rental properties are owned by non-residents. It's not the town residents that want these 14 amendments to zoning. However, a vocal group of non-resident absentee investor landlords are pushing for these changes so quickly. The majority of town residents are not in favor of these changes that will diminish the quality of life in this town, just in order to satisfy the insatiable appetite of more profits for some absentee landlords, not all landlords. I implore the planning board to oppose these changes and ensure a quality of life that all Narragansett residents deserve. Thank you very much for your time.
Thank you, sir. Anyone else, sir? If you can come up, state your name and where you live so we know you're a Narragansett resident. Thank you.
Hi, Paul Zonfrillo, 7 Windward Circle. A man once said, if you no longer love where you live, maybe it's time to refinance your house and contribute to the year-round rental pool. Of course, that was the newest member of the planning board. The contempt that this council has shown you, I commend you, Mr. Brady, for trying to do a really good job with these ordinances, fire hose down your throat. And, you know, there is a member of the town council who once said that she was an active listener. I don't know what that means, but I hope she's actively listening to you, because as you struggle to make this happen, and I can see you're trying really hard to do it within the law, it's pretty clear that what's happening is that under the requirement of state law, zoning changes that will really favor developers, really favor a member of the council are being jammed down your throat. I think it's horrible, and it's terrible. But thank you, Mr. Brady, very much for trying, and the rest of the planning board.
Thank you. Anyone else? Sir? Sorry, he was quicker. You're fine. Sorry, I just trying to break up some tension here.
Oh, yeah, I'll try.
If you could state your name and your address so we know you're from Narragansett.
Sure. My name is John Hanley. I live at 10 Wilderness Drive. Actually, I pity you. I think the council has dumped this on you. It's an impossible task. There's no way you can respond with legitimacy, no matter how hard you try. And I agree with the young lady that said they have disrespected you, because they have. I've been to the council meetings, and I see what's going on in this town. And it's absolutely absurd. It's a clown show. Now, I respect your position, and I tend to get a little excited. But what I will say, if I were in your position, because I'm not afraid to put myself out, what I would do is I would send back all of this stuff to the council, because every ordinance on there has already passed planning board muster in the past. I would send it back and say, we don't recommend any changes.
Thank you, sir. Yeah, young lady, she's moving. She's quick. Come on. No, come on up. Go ahead. We'll get to everybody. I'm not going to race anybody out.
Hi, yes, my name is Carolyn Petroselli, 74 Rockland Street. I wrote to the planning board, like I imagine many other people did as well, and I just want to reiterate, you know, I don't even think I have to say what everyone else has said. I agree wholeheartedly. But what I did say is I am in strong opposition to any of these changes in the 14 zoning amendments that the council has put before you, and I really do feel for you. I'm really sorry that you have to be put in this situation. From what I understand, the town council has not held any workshops on these proposed changes, and it was spoken about previously, nor asked for any public input. And I believe this is a reckless move on their part. It's drastic. And it doesn't serve, it only serves the non-residents and the investors and the landlords. It certainly doesn't help the residents that live here and have to be part of this community that they seemingly want to destroy. So it seems like it's wrong to dismantle these ordinances and these amendments that have been long debated and approved over the last 5 years or so by several town councils. So this was a long process, and they're trying to dismantle it with just this, you know, sending it to you and then having a vote on it. Thank you.
Thank you much. You can state your name and your address so we know you're a resident.
Sure. Jill Lawler, Sarasota Avenue. I want to start off by thanking you all. Director Sabo, former Director DeLuca, former Councilor Steve Marsala, who regretfully is not here to finish his fine work, former board member Jerry Barretto, who wanted another term but was not given that opportunity, Member Callahan, Member Friday, Dr. O'Neill, Chair Brady, and former Chair Fleming. The amount of work that you did, I personally know, the staff as well, the town staff, has been on the council 3 different times. I personally know how much work each of you have put into these ordinances. When Mr. Brady says 40 years we've been talking about this, let's just remember how this started. When Timmy Haxton was president in the 1990s, we were talking about the student dwellings and issues there. And every council since then has been talking about those issues. Up into the council of 2022, when we finally got it right, we finally achieved making sure, because 2100 was obviously watching and monitoring everything we did, that we followed the process correctly and the 3 student was put into place. As far as the bulk ordinance, zoning ordinance, the council I sat on 216 started that process going. What was occurring, and you all are witness to it, small lots were being built up. When you have a 5,000 square foot lot and you have a mega mansion put on it, you have problems. So to each of you, and especially to Mr. Brady, who brought up the fact that it takes at least a year to be able to understand what the planning job is. I can echo that. From sitting in those chairs up there, it takes more than a year for a counselor to understand their responsibilities and specifically what they're doing to you tonight with this amount of work. I think it comes down to they don't know what they don't know yet, most of them. They don't know how much work they're giving you. It's unreasonable. And I'm asking that...
Gentlemen, thank you. Continue.
To me, it's unreasonable. And they're asking you to do something that's just impossible. And I want to thank you all again for all the hard work you've done for the residents. For me as a resident, for the people who have spoken here, we really appreciate what you've done. You're getting dumped on, but again, they don't know what they don't know. So please, I agree with Mr. Hanley, send it back to them. Make them understand how unreasonable this request is. Because I believed every single one of them when they ran that they wanted to do what's best for the town residents. Even in the last week when we had a meeting about the short-term rentals, the notice that was written was we have to come to the best solution for town residents. It said nothing about investors. So I know that you're for the town residents, and I really appreciate all the work you've done. Thank you.
Thank you, Mike. Thank you. Anyone else? Sir? Again, if you can state your name and your address so we know you're a resident of Narragansett.
Thank you, Planning Board members. Stephen Ferrandi, and I live at, I guess it's an infamous street name now that it's out in the public pretty good, Sylvan Road, 44 Sylvan Road. And this is one of the, on that particular street, that was one of the reasons why, you know, things like the bulk zoning were used. And with all these ordinance changes, it's going to get worse on my road. So it's kind of been said before, I really appreciate the planning board, you know, with all the work that they're doing, and it's not your fault that this is happening. This is what's called bad government, what we're seeing right here. It shouldn't be like this. I can go back from 1987 when I used to come to the meetings, and that was like the first rewrite. Black Point was possibly being condos, the town was being overdeveloped. And at that point, a lot of residents and the people thought the town was going to be all condominiums. So believe it or not, that's where the first rental registration started. Town never did anything with it till 10 years ago. So a lot of good things happened. A lot of councils had looked at that. And all of that was public for 6 months before they tried to rewrite the whole zoning. This is ridiculous what's happening here. And I'm not too convinced that people on the council don't really understand what they did. Because if you read the motion, it says, by Donna Vignali and Alex Menzies, a motion to act on providing the town solicitor on amendments to the zoning ordinance, planning board recommendations, Floria, and it lists you in the planning board recommendations. They never discussed anything with you. And then it says the reason why. Suggested action is the topics described in this agenda item were brought up by the town council's attention for review. This request is the council's plan for reviewing these ordinances and working the planning board and the town solicitors. Well, I guess they must have talked to a lot of people or got a lot of complaints, because to rewrite this whole zoning ordinance, they must have talked to everybody in the town, and they didn't. And the solicitors for coming up with this, I get it. We don't know where they came from. Well, someone wrote all of this, okay? So if they directed the solicitors, they wrote it all. I don't know which solicitor did it, who did it or not. Might not have been yourself. There's only two other solicitors, Mr. Callahan and Mr. Craven. So where did all of this come from, if this is coming from the solicitors? Did the council have discussion with the solicitors and say, okay, this is what I want, this is what someone else wants, you know, this is what one councilor wants? What happened? This is totally ridiculous what's happening. And that's a key thing. It's just disingenuous to be doing that. And they showed their cards. You know, maybe Alex didn't understand it and then it comes out like this. Well, you got to understand what you're doing. I think it was predetermined that these were the ordinances that someone wanted to change. And all in a row as quick as they could. And because that was for the special interest. Or someone over there is for the special interest. I mean, it's ridiculous what... If you could end. Yeah, okay. I won't go into detail with everyone, but, you know, I think people should not be happy with the council and the way they're acting at this point by pushing so much. Thank you.
Thank you very much. Anybody else? Anybody? I'll give you a minute. Okay? No, please, you have to come up. We have to be able to hear you. People at home have to hear you. Please, again, state your name and where you live.
Thank you. Gail Scowcroft, 19 Prospect Ave. I'm looking at this schedule and realizing just how incredibly disrespectful to the residents this process is. These are 4 school nights. How are parents going to come out and educate themselves and have input regarding all of this? It's an impossible situation for the parents of this town as well as all the rest of us. Thank you for letting me say that.
Good point. Good point.
Anyone else, folks? Okay. Thank you very much. Again, this is just public comment. This is not a hearing. We are not acting like a hearing. We cannot respond and will not respond to anything. But understand, we heard you. Also understand that we cannot respond legally to any emails, texts, or otherwise. So we thank you very much.
Mr. Chairman, can these people speak again at these hearings?
Yes, I think I've stated that before. I'll state it again. Because you spoke here, it does not disqualify you from talking at a hearing. I would encourage you to take a picture. So I don't know about you, but I haven't slept much since this has been brought up. So I wouldn't remember this. So if you want to take a picture, please take a picture. I would like to entertain, if the board would entertain, a 5-minute or 10-minute recess. Hold on, Mr. Callahan.
Mr. Chairman, if you got to come back after, we're not going to discuss this again tonight?
Yeah.
Just have one.
Well, no, wait a minute. No, let's just finish this because I have some business. And before anybody in the town makes a big deal about this, Steve and I talked before about this, so I'm not throwing anything or trapping him or anything. I requested from Steve, because he is a builder, and again, this is new for us. We've not had a builder. We have always operated, even though, again, it's not the state law, we have enabled ourselves that if it's a perception of a conflict of interest, it's a conflict of interest. So the town council had a workshop with the Ethics Commission, and I spoke to her. She is the chief legal person there, and I think a head investigator. I'm not sure what her total title was. But I mentioned the fact that this is coming up, that these ordinances coming up. And Steve's a builder. He's never been shy about that. His dad's a builder. And so the recommendation, and I've asked Steve, and he said he will do it, is to request from the Ethic Board I call it a preliminary, I know that's not the legal name of it, an advisory decision as to whether or not there would be any conflict or ethics issues for him. They will send him a report, and I asked him if he could forward that to all of us. So it's in the record one way or another. So there will be no doubt from people in the town that we are front and center with being very visible about what we're doing. Any comments from any other board members?
Not on that issue, but I have one more thought about this particular issue.
Let's move to business.
There are a couple things that will be discussed. For example, bulk zoning regulations, two-family dwellings, for which specific information, at least from my judgment, would be helpful. So, for example, on the two-family, one of the justifications on the two-family, as I recollect, was impact on utilities, particularly water and sewer.
Yeah.
Understanding kind of the demand issues, seasonally, treatment, the rest of it, as well as there seems to be a lot of what's seemed to drive some of the discussion is a sense that getting a permit is difficult. Getting a variance is difficult. On the bulk side, it would be interesting to know how many applications, for example, over what period of time, how many actually ended up coming to making their way to the board as opposed to being decided administratively at the staff level, so that we can get a sense for what's real in terms of numbers and data. How do we get, as we kind of go through this, I think it would be useful for us to think in advance of what information we don't currently have at our fingertips that we need to have in order to make intelligent decisions as we go forward, and get that to you and to the staff prior to that night's discussion.
Yeah, this is part of my shopping list. Water and sewer is also critical. I don't know if people know, but URI and we lease a lot of our capacity from the university, bringing on 1,500 beds. And so they're going to want that capacity back. Our sewer and water is over. So these are issues that I have here. Here's the thing, though. I don't want to overload staff and everybody. So what period of time are we talking about for these decisions?
I guess I'm not prepared to give you a number right now. What I'm saying is,
Okay.
if we could get to you and/or staff, however you decide you
I
want to do it.
prefer right now if we traffic through me and staff has got.
Get it to you, and then say, the following information would be useful to me in the context of talking about these specific things going forward on a night-by-night basis.
Okay, so if you're going to send me requests for information, that has to go through staff, or else it violates the open meeting law. And then staff can forward it to me or whatever. I will try to do whatever I can do as far as research is concerned, but I think I've already started writing a shopping list, and I think some of this is valid. Steve, you look like you want to...
I do have a few things. I don't want to prolong this overly, but in reference to that particular question, as a builder, there's land for sale in Narragansett that I have not purchased due to the perceived difficulty of getting permits and building houses in this town. And I'm sure there are other developers or builders who feel the same. That's anecdotal. I'd love to see the numbers too. I think that's a great idea. The only other thing I wanted to say is our town council was elected. They're adults. They have agency. And many of them...
Again, we're not going to address any of this because that makes this a hearing, and this is not a hearing.
Oh, sorry.
And I'm not going down that legal rabbit hole.
Apologies.
Thank you. We'll state the subject, gentlemen. Rupert, anything?
Sort of on the topic of information, I agree about the sewer and water capacity. I think another a similar thing is modifications. How many have come through, and how many have been approved, denied, and sort of what was the basis for denial of any of them? It seems to me that the standard is such that I can't imagine how you could choose to deny it. And then...
Again, I would like to remind everybody, the level of information that we are asking for is, just in generalities, is almost like shoving these down somebody else's throat. This staff is swamped right now dealing with this and dealing with everything else. So I ask you to really consider the time frame that you're looking at. And I would argue strongly that what happened 10, 12 years ago, or even 5 years ago, is not relevant to what's happening now. Again, I will try to do research if I can. I would urge everyone to do the research if they can. What I really, and I'm not looking for discussion here, but I'm really, really telling you, this staff is drowning right now. Okay? So I'm writing these down.
So modifications have only been in place a year.
Okay.
And then the other issue is substandard lots, like how many lots less than 5,000 square feet in R10, and sort of similar for the different zones. And I think that information may have been compiled before, but I don't know.
Yeah, we had that before. Okay. Anybody else? Doc?
My little sarcastic comment here. I think the one person who spoke said it very well, is there's nothing wrong with saying if we can't get an extension of whatever we decided on, 90 or 120 days, to just say the material before us stands. You deal with it. So it's my sarcastic comment.
Thank you. All right. I'm going to request, is everybody finished with this subject matter? All right. I'm going to request from the board if we can have a 10-minute break. I need to get something to drink and do other things. And I want to truly thank the applicants tonight, because you did not expect this. This is not what you bought into. And just so you know, we have 1, 2, 3, 4, 5, 6 proposals that we have to get through tonight. All right. We will be back in 10 minutes. Please, it gives you an opportunity to stretch your legs. Thank you again. If you see, we're pretty full, and that is typical. We try to, because there is so much work going on in Narragansett, we try to get as many projects as we can in a given night. That said, we're not racing you through. We're here to listen. For those of you who haven't been before us, while this is a legal procedure, we try to be conversational. And so please, we don't bite. Take a deep breath. Relax. Okay? Everybody set here? Yep. Staff? Council? Okay. So on our agenda, first up, Cherry has been continued. So that is D1, site review. So site review, D2, Gabriel, plot N-R, lot 1940 Clara Lane. Okay, some of the applicant is submitting a request to legalize an existing bedroom, increasing the total number from 4 to 5 bedrooms at the above-mentioned property. This project requires a special use permit from the development standards for homes exceeding 4 bedrooms, section 12.13. Existing condition, lots 19 is approximately 10,000 square feet in size and is located in R10 zoning district. The existing 24 by 42 4-bedroom single-family dwelling and a 6 by 8 front entry deck with stairs and a rear 11 by 12 deck with stairs. The existing building and lot coverage is approximately 13%. Proposed is a request to legalize a 5th bedroom. Proposed building lot coverage will be approximately 1,312, 13%. Obviously does not change. Okay. Proposed parking areas comply with section 7.9 of the zoning ordinance, 300 square feet per bedroom, as the project proposes 1,806 square feet of on-site parking for a 5-bedroom dwelling. A future land use designation of this property is residential high to moderate density. The project was proposed, appears to comply with the land use component of the comprehensive plan. Relief request, 12.23, development standards for homes exceeding 4 bedrooms, special use permit. Okay? Counselor, I gave the Reader's Digest version. I turn the floor over to you.
Good evening, Mr.
Welcome
Chairman.
back. How have you been?
Fantastic. I get paid by the hour. So.
Yeah, I'm.
No, this is a flat fee. I just.
Thank you all again.
Jack McGreen for the applicant, 21 Garden City Drive, Cranston, Rhode Island. Applicant and owners are Gregory and Susan Gabriel. The property is located at 19, Plat NR Lot 19, located at 40 Clara Lane. The Gabriels purchased the property in 2005. At the time they bought the property, it was listed as a legal 5-family. They've been renting it as a 5-family since 2005. Without any problems, they limit their rentals to the Division I athletes down there, either soccer team, the women's soccer team, or the volleyball team. So the way this came to the town's attention is because of all the discussions about short-term rentals. My client actually came down to make sure she didn't have a problem. She talked to the building inspector, asked to see the card to see what her card said, and it turned out that it is a 4-bedroom, not a 5-bedroom. So they gave her a denial and said you'll need to go to the zoning board. That's how it came about. It's always been a 5-bedroom. It's never been anything but a 5-bedroom. So that being said, the special use permit request meets the development standards under section 12.3. You have some objective standards you have to look at. The site, number 1, the site's a legal non-conforming lot of record. 2, the houses on the property meets the definition of a single family and requires no additional special use permits or dimensional variances. And 3, the property has adequate parking on site that meets the requirements of the 300 square feet per bedroom as required under 7.10. With that being said, we do meet the development standards. I do have a couple of additional pictures that might better show you where the property is located. The first set of pictures is, it shows that
This is going to our secretary du jour, and he
There
must
we are.
accept them.
There we go. There we go.
that first picture just shows the property is actually picture, I think, is a better representation of what the driveway looks like. There's plenty of room for 5 cars, probably more than 5 cars, and like I said, it does meet the design standards of the ordinance. So with that being said, I can answer any questions, and obviously I have my client here to answer any additional questions that you may have.
Okay. Dr. O'Neill?
Yeah, staff, we have a floor plan here with a printed name, no date, no stamp, an architect or whatever in front of us to vote on. And another negative, the plan shows, hopefully the applicant is well aware of it, storage area with a door, windows, proximal to a bathroom. Where I come from is a bedroom. At least this board has considered it as such in the past. So that would be 6 bedrooms. But this plan in front of us, I can't, how can we accept this? It's printed with no date, no signature, no, I don't know about my colleagues, but it's hard for me to vote on something like that because, well, as I say, there's no signature and there's no date. And the fact that the storage area obviously has the potential to be a bathroom. This applicant may not decide to use it as a bathroom, but the next applicant will. The next owner will.
Sure. Dr. O'Neill, just to clarify, the floor plans aren't changing at all. This is existing. This is how it exists. And the building official didn't require them to provide full-to-scale plans from an architect. I can, however, also say that the building official has reviewed and accepted these throughout their review process, and I believe the fire marshal has also looked at them, reviewed them, and put his 2 cents into it.
Okay. Point of information, if I could intercede. The window in the storage, and I have this in my notes, but I think it's pertinent to this conversation. The window in this storage room, is it an access egress, or is it just to allow sunlight in? Because that does make it. All right, so it's a double-hung access egress window. So then legally it would make it a room.
The question is your storage that has a window, the storage area has a window? It does have a window, but my tenants don't have access. Yeah, so just so you know, the applicant uses that because she lives, you move in the summer, so that's the only place she has to put her stuff with the locked storage unit for herself, and the tenants do not have access to that unit.
Yeah, and my point is not, most, not everybody, but most people come before us are pretty straightforward and honest. It's the next owner. It's like a.
You bring this up all the time, Dr. O'Neill, and respectfully, that's an enforcement issue.
Yeah, well, I know, but nobody goes around and knocks on the door.
Right,
Come
but
on,
it's an enforcement
Jack,
issue.
come on,
It's
Jack.
not an issue that my client needs to address, quite frankly.
Yeah.
She stores her stuff there. It's never changed. It's been here since 2005, since she bought it.
Right. Yeah.
Thank you.
But again, back to, you talk too fast, Ryan. I don't understand how that's acceptable planning of the floor plan presented to this board.
Again, I'm going to defer to the building official accepted it because there's no proposed changes to the layout of the development. It's staying as it exists today.
Yeah. Well, not to publicly complain, then Wayne has a problem. No, does anybody sitting here, look at, put
Right,
it
so
back up?
Dr. Neal, just to that point, that the applicant is before you today not for any approval of any actual construction. They're looking for the approval of the 5th bedroom,
But who says that's the inside of the house?
Both, I believe, the fire marshal and the building inspector.
They went through it? The fire marshal and the building inspector went
I would
through
ask
the house?
Mr. McGreen to confirm that, but it doesn't happen in our department.
He doesn't inspect a lot of other things. Why did he go here?
I'll bring my client up to testify, but she has told me that the building inspector and the fire marshal have been onto the property on several occasions. She has had some work done, and people have gone out and looked at that, and they've never raised the issue of the fifth bedroom. So there are other
Right.
people from the town have been out there. And by the way, we would welcome the town to come out and inspect the property if that's what you,
Right.
if that's what they want to do.
Right.
No problem doing that.
Right. But the point is it's an issue of consistency. We have had a rare owner come in, but again, it's signed, it's dated, and it's a minor whatever where we've accepted this kind of plan, but,
We're not looking
like
for a
that.
permit to
Now,
construct the
go back to that, to the overview, yeah. Now, that has, I don't have the page in front of me, but that has either a landscape architect or somebody's name is on there that sanctifies that and says that it's accurate, you know? It's just, it's a point of, I don't understand why we're not consistent, you know?
And we do have
Or don't show us the inside of the house. We've had people try to do that too. So.
Well, quite frankly, I did it as an overkill. Quite frankly, I didn't.
If I can intervene, and I'm not mean to cut you off, but I am cutting you off. I think what Dr. O'Neill is saying is that in-house, we need to look at some consistencies as to how we do this. I don't think he's calling into question your client's credibility or anything else. But what he's saying is that we need to have some standards. Do we have any standards? What are the standards? So I think that's his question. And it's not, the onus isn't on you or your client. He's just frustrating about internal stuff. And we can take that up someplace else.
From a practical point of view, the only thing that the objective standards that we need to show is the parking. We paid somebody $2,500 to do that. Why should we have to pay an architect another $3,000 to show you a building that already exists and we're not asking to do anything to it? That to me is overkill.
Okay, thank you.
Because you're asking me. Okay. Well, you represent the client and you're an attorney, so I respect that, Jack. You're a good attorney. No, you are. But for me to vote on that piece of paper, it's like, it's an incomplete presentation as far as I'm concerned. But in any case, my colleagues don't feel the same, so, okay.
So my question is similar to a little bit of what Dr. O'Neill said. So why is it not a 6-bedroom house? I understand she's using it for storage.
That's a storage unit.
I understand she's using it for storage.
Correct.
But it has a window and a door. It could be a bedroom.
Right,
Like
so
it-
if she
most
was,
people looking at this, I would
if she was
guess
if
it's
she
a
was going to
bedroom.
be building a new home, you could come and say, well, we want the door taken off, we want that widened to 6 or 8 feet, I think that's what we do now, in order to make sure that that won't be used as a bedroom. But we're not doing any construction with this house.
I understand.
We're just trying to meet the development standards for a 5-bedroom home, and we need to we need to show you that it meets the parking requirement.
I understand. I guess my point is, to me, it looks like a 6-bedroom home, so you should meet the parking requirements for a 6-bedroom home.
She could meet the parking requirements for a 6-bedroom home, but it's not a 6-bedroom, it's a 5-bedroom.
Okay.
There's plenty of land, if you go into that, there's plenty of property there to even throw another parking space in there, if that's your concern. I mean, but they're not. She doesn't want to use it for 6, only a 5.
Okay. Yeah, and actually seeing the drawing, I agree with you. It would, right? Yeah, okay.
Yeah, she could, there's a bunch of configurations, but she could easily go, 1, 2, 3, 4, 5, 6, all along the edge here, 2 feet off the edge, and still be able to turn out, and each car could turn out in a hammerhead style turn and go out forward in a forward direction. So there's enough room there for another car.
Okay.
So that really.
That is a point I didn't notice, but yeah.
Good, you all set? Tom? Steve?
I just have one quick thing. I know we can't compel this, and I wouldn't want to, but I would ask if you'd be willing to paint the parking space, just some lines. I know college kids, they're brilliant, but they never park where you think they're going to park. They park all over everything. I know you know because you own the house.
If I was a neighbor, I would not want to have stripes it looks like a commercial piece of
enough.
property.
Fair enough.
Okay. All right. Staff?
I have no further comment.
Okay. Legal? Okay. I would like to also point out in staff's report that in review of the above criteria for a special use permit under section 12.23 of the town's zoning ordinance, it appears that this project satisfies all necessary requirements for homes exceeding 4 bedrooms. So, all right. I have no questions. Do I have a motion? No, wait a minute, redirect. Oh, wait a minute, public. I'm sorry. I'm tired, folks. I'm sorry. Does anybody from the public wish to speak? All right. Applicant, would you like to say anything? Counsel will advise you not to. Take counsel's advice. He's a good lawyer. Okay. Okay. Doc, redirect?
No.
Okay. Rupert? Tom? Good. Steve? Good. Okay. Would you like to add anything?
That completes my presentation.
Thank you. Do I have a motion?
So move the application before us. Gabriel, tax assessor plat NR Lot 19 is complete and in conformance with town comprehensive plan.
Seconded? Second. All those in favor? Aye. Unanimous? Do I have a motion on a recommendation to zoning?
Chairman, I'll make a motion that we recommend the zoning board approve on Gabriel tax assessor plat N-R lot 19. Recommend the the zoning board approve the application and include in the record the memo from staff to you dated February 12, 2025.
Okay. Do I have a second?
And grant the
Yes.
special use permit, yeah.
Thank you. Counsel, I should have asked this, and I apologize, but you're aware of the conditions, they're standard conditions.
Yes.
You guys are okay with that? Okay. I have a motion. I have a seconded. All those in favor? All those opposed? It's unanimous.
Abstain.
Abstain.
I abstain.
We have an abstention.
Inadequate information.
So,
Thank you, Mr. Chairman.
thank you very much. Good luck. All right. Young lady, we need to get you up here and get your babysitter out. They can be more expensive than an attorney. Yeah. All right. In the book, it's D3, folks. Kitson, plat N-S, lots 36 and 37, 63 Colonel John Gardner Road. All right. The applicant is submitting a request to permit legalize a previous conversion of an approved previous driveway to an impervious material at the above referenced property. This property is located in a coastal resources overlay district, section 4.4, and a special floodplain, section 4.7. Previous applications. The property had received the following zoning approvals. The zoning board approved dated January 6, 2000, for the construction of a 40 by 55 irregular shaped single-family dwelling with a pervious driveway. Findings of fact. Existing conditions. Lot 37 is approximately 15,202 square feet in size and is located R10 zoning district. Existing 40 by 55 irregular shaped single-family dwelling with a 6 by 28 rear covered porch with steps and a 9 by 49 front covered porch with steps. Existing building and lot coverage is approximately 2,513 square feet, or 16%. Proposed improvements. Permit legalize existing impervious driveway. Proposed building lot coverage will be approximately 2,513 square feet, or 16.5%. No change. The request here is due to medical. Staff notes that this lot is within the R200 CRMC Coastal Resources Overlay Buffer, and that the paving of this pervious existing driveway was not reviewed by CRMC. Approval of this application will be contingent upon CMC's review and approval to address any additional drainage. Do you understand what that means? Does anybody explain that to you? You have to go to coastal, okay? And regardless of what we do, whether we recommend what, it's going to be contingent on you doing that, okay? So, zoning approval is contingent upon the issuance of a right-of-way permit by the Department of Public Works for the driveway's apron. The zoning board approval is contingent upon the issuance of an assent by CRMC for this proposal as project as proposed. If CRMC were to be modified, the site plan, this project may still be approved provided additional zoning relief is not necessary. That the area of disturbance be reseeded or sodded with low-maintenance conservation grass mixture, only slow-release fertilizers are permitted, an intact vegetation cover. Okay? Folks, the floor is yours. Talk to us.
We don't even know where to begin.
It's okay. Why don't you tell us your story? Can you pull the mic to you so we can hear?
So we moved into the house and we immediately paved the driveway. We have a daughter who has no deep veins in one leg. So she requires a significant amount of exercise to keep that blood flowing. We felt like the street was not a safe place for her to be doing that. We did have one incident where we've had college kids that drive pretty recklessly. And basically we use the driveway for her to exercise. And I have to say that we're a little bit frustrated with the number of driveways in Narragansett that I now know are probably never been permitted, and yet we are the only people that are being called upon to fix our driveway that I'm aware of.
There's other stuff going on. It's just you're not aware of it. So let's just focus on you and
Right.
getting your stuff.
So
Okay?
I guess our next step is to go to coastal?
Yeah. Okay.
No.
And that's, no? Then say something to me.
Mr. Brady,
Yeah.
for clarification, the next step would, well, first, they would have to obtain your recommendation.
Right.
And then they would move to zoning.
Zoning, and
then
then-
they would move to DPW and CRMC to obtain the permits needed.
So eventually. All right. Sorry. I'm like zoning here, crushing a little bit.
So one of the, when this came up, we got the call from Wayne. You guys he wanted a site plan, all this engineering done, not even, not even going to coastal. This is before that. We got quotes to do all this stuff, and we're into $15,000 just for that, and then we could spend that money and then still get told
tell
no.
us no.
So we think that's kind of silly. I mean, honestly, we have 5 kids. That's a year of tuition at URI,
So we're not questioning that. What we want to do is hear your story as to why you needed to go from pervious to impervious. And so your daughter's situation.
Right.
So does she have physical therapy stuff that she is defined to do?
So she recently had surgery, which she's recovering from, but we probably have at least 4 more years before we can completely rectify our situation.
Okay.
So I have a folder full of MRIs and X-rays.
Don't need 'em.
I have a doctor's note from an orthopedic surgeon saying that, she benefits from that space. I mean, it's hard for me when one kid says, I need to go outside and exercise, to then drop everything with other children and say, so this was sort of a way to be independent. We put a basketball hoop up for her. She can safely ride her bike there. She can, hula hoop, run around.
Great. Thank you.
Thank you.
Doc, questions?
Yeah, yeah, again, I don't want to spend your money, but have you looked at putting in some way of handling the runoff from this? Because that's going to be the problem
runoff,
with.
We haven't had a major issue with runoff. If you were to drive by our house, you would notice that the driveway slopes into our garage. So if there's runoff, it ends up in my garage. There's nowhere else for it to go. There's pavers that go all around the driveway, and then it would go right in the door.
The reason that the property you got there, and the reason that it was to be crushed stone or porous is because your proximity to the water. So I don't know how you're going to overcome that argument. But as far as the driveway and the, don't you have a neighbor who complained? Why don't you address the, if it runs to, I mean, people in here all the time with rain gardens and other ways of correcting the runoff, you know?
There's a little more to this.
He wanted 3 feet of our land, and we wouldn't move property.
Yeah, well, that's a separate issue. But I think that's when, if you're going to go to coastal, to keep that as a solid, that's a pretty big, I've been to your property. It's a pretty big driveway, a pretty big piece of asphalt, you know? So I think that's, you know, regardless of your daughter's problem, I think, you know, you're in a bind because of where you live, where you bought, you know, proximal to the water, and the fact that the original permit was for crushed stone for a reason.
Right, which I didn't know when I had no idea.
Yeah. So, in any case, those are my thoughts on it.
Okay. Rupert?
Yeah, I guess the question I have, it seems like you can use pervious pavers and it still would work for bicycles and hard play surface instead of crushed stone. And that would probably address the CRMC issue and the reason in the original condition. I'm confused a little bit by the timeline. The zoning decision was January 2000, and the driveway was paved in 2019. So it seems like the decision to have pervious pavement was after the driveway was paved?
So the original owners put down the crushed stone. We purchased the home. We lived elsewhere, and when we moved into it, we put down the driveway.
Okay.
For the kids.
Yeah, the previous house we lived in had like a stone driveway, but it also had a tennis court in the backyard, so they could.
Yeah. Well, I just noticed, I don't know, a house 2 doors down from yours has pervious pavers, and it seems like it's a solid surface that would work for bicycling and playing and stuff.
That would have been a better choice.
Thomas?
Just a question for staff.
Tom, if you can go into the microphone.
Question for staff. Is this, the 16.5% lot coverage includes the parking area?
That is correct.
And is that within the parameters, the allowable parameters for that size lot?
That is correct. I believe it's 22%.
Okay, thank you.
Steve?
Hi, guys. I'm going to try and help you out here. I understand engineers are expensive, and so is council, but they may have helped you here. What I'm going to say is, on my site visit, I did notice that you didn't pave the entirety of your driveway. Where the driveway slopes towards your garage, you're absolutely right. Almost your entire driveway slopes, and I don't have a contour plan, but I have a pair of eyes. It all slopes towards your garage. You have crushed stone there to infiltrate the water that comes. You are going to need an engineer to verify that that infiltrates enough water. At the other edge of your driveway, above the black car there's another infiltration center which picks up the rest of your runoff that doesn't run towards your garage. So I don't particularly have a problem with this as long as CRMC, you got to have an engineer say they're infiltrating enough water so no water's going on your neighbor's property. That's kind of the reason they do this thing, and you're within the coast. They don't want to be shedding water onto the coast. But I can see that you thought about that when you put the pavement down, because you do have infiltration points at both low points of your driveway. And I appreciate you doing that, because you could have just pretended total obliviousness and just paved the whole thing and been dropping water on everybody. So I think well done, and that's all I've got.
Yeah, when I went out, that was the first thing I looked at, because you're within spitting distance of the ocean, and CRMC is going to ask questions. So I did not go on your property. We don't do that. But I could see that you didn't know how effective or efficient, or if they were large enough. And I do think you're going to have somebody, a professional, come out, because CRMC is going to want that, to look at controlling that runoff. It's not good to have runoff going into your garage. They're not meant as retainment areas, okay? And it also will solve a problem with you with your neighbor as far as that issue is concerned. There is, believe it or not, pervious asphalt. We had to put that down. That was a requirement when we redid our driveway. So there are alternatives. That said, you're here now. So that was my biggest thing is controlling the runoff from this. And again, I don't know if either of those are large enough or the slopes are right, or if the materials there are sufficient to deal with the runoff from it. And I think you're going to have a professional do that. And the reality is, you know, you're going to have to face CRMC, and you're going to have to work with them, and it might be good to have a professional on hand when you're dealing with them. All right? Staff?
I have no further comment.
Okay. Council? Okay. You guys want to add anything?
So as we've sort of gone back and forth on it, what would the timeline be if we were going to just go back to the stone? Like, I mean, how long do we have to?
I don't think anybody's here has said go back to the stone.
Well,
Okay.
but in terms of, I mean, I think when we are looking at the numbers here,
We
I don't
can't,
know that this is
we can't
something
tell
that-
you what to do. Your next step would be to zoning. First of all, you need to get a recommendation from us.
Okay.
All right? And if we approve, it's probably going to be conditions. And so you got to look at those conditions. Zoning's going to look at those. And then you need to go to the next step. Staff?
Yeah, so Mr. Reed, I just want to clarify. You mentioned a few minutes ago about the prohibitive cost of a site plan. The building official has waived the requirement for a site plan or for OWTS. I believe he provided you an email, Mr. Kitson, waiving the need for a site plan?
I didn't see that, no.
So you want to thank Wayne?
Yep.
Yeah.
It's okay. I got it, yep, right here, to you, Mr. Kitson, on December 23rd. There is no building review form, site plan, OWTS, as this zoning condition variance is due to a zoning violation.
Oh, I didn't pick up on that.
So that's good news.
That is good news.
It is good news. So I'm not telling you what to do. I can't. And he doesn't look quick, but he's quick, and he will stop me from getting involved in your project. But you have another step here to feel things out.
Yeah, one thing, I'm surprised my colleague over here, he's just a wonderful, generous guy, didn't bring up, you may want to go home and think about what our conversation just was here. Because if, like was mentioned, if it's expensive, but what isn't going to be, the way you guys are going. Putting down pavers is going to solve your drainage problems, and you don't have to go to coastal and whatever. I mean, you may want to sort of think about, do you want us to vote on this? Because what's before us, it's hard to vote on, because you violated the zoning requirement to have that as gravel. So it's you make that decision.
Yeah, I'll just add to this. Regardless of what our vote is, you have options, okay? So our vote is a recommendation to the zoning board. So that'll tell you our barometer to the zoning board, and they'll take that under consideration. So again, you have time for decisions, okay? All right. All right. Rupert, redirect, anything? Tom? No. Okay. Steve? No. Okay. Staff? No. Do I have a recommendation?
You have to move on that completeness?
Yep.
Okay. Move the application before us. Kitson Tax Assessor Plat NS Lot 37 is complete in conformance Town Comprehensive Plan.
I'll second that.
All those in favor? Aye. Unanimous. Do I have a motion on a recommendation to zoning?
Mr. Chairman, I would like to move on project summary Kitson, tax assessor's plat NS Lot 37, location is 63 Colonel John Gardner Road. I'd like to recommend that the planning board approve the requested relief, the amendment to the January 6, 2000 zoning decision, as outlined in the staff memo from Ryan DePani to you, dated February 12, 2025, with the conditions that are listed on page 2 of that summary.
I would like to add a friendly amendment to that, if you would, that a professional engineer look at the runoff containment and make a recommendation on those, or at least review them and to see if they're sufficient in size, if they have the right materials. It's going to help you going to CRMC anyways. Okay.
Yeah, I don't have an objection to that. I just, again, this is a recommendation to zoning.
It is.
What they might need for CRMC.
No, but
is a
I'm,
little- is a
as
little
our
different.
recommendation, I would think a condition, a valid condition from the planning board would be that a engineer look at the runoff containment and make sure that is up to grade, both size to contain the runoff and materials. If you don't want to include that, you don't have to, but,
I think I'd rather fly without this one.
okay,
Yeah, Mr. Chairman.
okay. That affects my vote. Okay.
What I guess the reason why I'd rather fly without a mark is I'm not sure if you require that analysis, what happens with it? How are you assured that it gets done? Number one. And number two, my presumption is that they'll have to do that anyway to get to CRMC.
It's conceivable, but if they don't do it at zoning, zoning's going to catch it. And so that's why I'm including it. I just think it's, given the scope of everything, again, trying to be reasonable here. I don't want these people to spend money they don't have to. But I think it's a reasonable thing to look at the existing runoff containment to determine whether or not it's sufficient for what is there, both in scope and in materials. And I think it would be prudent for us and the neighbors, et cetera, to include it as an appliance. Now, whether or not they do it, zoning will catch that. So that's just my thought.
Mark, I'd like to have you vote, but I think I'm going to fly without it.
Okay, sounds good.
Yep.
All right. That's okay. I need a second.
I didn't hear a second.
I'll
Okay.
second that.
All right. All those in favor?
Negative in terms of what's presented and.
Okay. I just own the ayes here. Folks, this is just a recommendation, okay? It is not, you have to go to zoning anyway. I would have voted in favor of this if that was addressed, because I think it's key. I also think it's key for you going down the road with CRMC. I wanted to approve this. I can't not without that. So understand where I'm coming from. So I have 2 in favor.
I'm negative also.
Okay.
Oh, negative.
So I have three negatives and 2 positives. So the recommendation is not to approve, okay? It's just a recommendation. You've heard what we've said, and you've heard our concerns. It's up to you to decide if you want to address things before zoning or when you get to zoning or whatever, okay? All right, good luck, folks.
Thanks.
Okay?
Yeah, I thought your paper idea, I never even thought about that, in the porous asphalt. It's a,
2 doors down.
this is doable, yeah,
Next up
this is doable. Yeah.
is
These are already signed?
Gabriel, Kitson.
These are ready to go to?
Asante?
okay.
All right, Asante, Plat W, Lot 77, 20 Gull
She has them
Road.
already.
The applicant is submitting a request to demolish their existing deck and construct a new deck with an attached gazebo at the above referenced property. This project requires a special use permit from the Coastal and Freshwater Wetlands Overlay District, sections 4.3 a variance and special use permit from the Coastal Resources Overlay District, Section 4.4, and a variance from the Dimensional Regulations, Section 6.4. Existing conditions. Lot 77 is approximately 38,217 square feet in size. Is located in R40 zoning district and is currently occupied with a single-family dwelling. Lot 77 has an existing 24 by 34 rear deck, 2 on-site sheds, and a gravel driveway. Overall building coverage on the lot is approximately 3,008 square feet, or 7.9%. Proposed demolition of existing rear yard deck, construction of a 20.8 foot by 19.9 rear yard deck and stairs with an attached 10 by 7.5 gazebo. Proposed overall building coverage will total approximately 3,332 square feet, or 8.7%. The zoning board approval is contingent upon CRMC for this project as proposed. Staff notes that the existing right side yard setback is 20.8 feet, which is existing, non-conforming. The proposed rear gazebo will be 20.8, which is the same from the side yard setback, and will not require a variance, as it will be no closer than the existing corner of the dwelling. However, the proposed gazebo will be 30 feet from the rear setback, which necessitates a 5-foot dimensional variance, as the applicant proposes to demolish the closest point of the existing deck. Relief, Section 4.3 Coastal Wetlands Overlay District, special use. Section 4.4 Coastal Resources Overlay District, 108.1 feet variance of special use. Section 6.4 Dimensional Regulations, 5-foot rear side yard setback variance. Sorry, sir. Thank you for waiting.
It's okay.
All right. Would you introduce yourself and tell us your story?
Yes, my name's Russ Guido, I'm the contractor for the Asantes. I've been tasked with building a new deck. To make it short, we're only extended, we're tearing down the old deck and building a new deck, but we're only extended towards the water by 4 feet. But then there's this gazebo on the other end of it that's extended another 5 feet besides that. We're not infringing on the next door neighbor's property, as you've seen by the numbers there, the 20.8 square feet border. We're just extended towards the water, and as you can see, it's peninsula. We're not bumping into anybody else's property or heading in any other direction. However, I've been told by the homeowner who's been waiting for this deck for a while that if we have to eliminate this gazebo, if that's the big holdup here, which it appears to be, is that he would be okay with just doing the 4-foot extension on the deck.
So moved.
Questions to staff. Does the configuration of this point add to the issues of this site?
The lot is unique. There are unique characteristics of the lot, absolutely.
Thank you. Okay. All right. This is also an elevated deck and an elevated gazebo.
4 feet, the gazebo out there would, of course, get higher because it starts to slope down towards the water.
Okay.
Might be 6, 7 feet.
Okay. Thank you.
Yep.
Dr. O'Neill?
No, I think the gentleman offered a possible solution to my problems, and that's that if the gazebo isn't essential, which, that decks, gazebos, and all those things are all pleasant and wonderful things. I have a little deck. But to extend toward the water, even though it doesn't extend toward your neighbor's property, or his neighbor's property, it still extends toward the water. And, we, as a board here, we've always tried to protect every coastal feature in terms of use, because hopefully the gazebo would be used then. And, its proximity then to the water is what bothers me. So if the gazebo can be eliminated, I would support the rest of the project in terms of decking, et cetera.
Thank you.
Rupert? Yeah, I feel pretty much the same as Dr. O'Neill just explained. It's a substandard lot, so that the setbacks are already reduced because of the difference. So I have concerns about the extra 5 feet for the gazebo.
Yep.
Tom?
I guess I have a question either for the applicant, contractor, or staff. I'm just trying to figure out.
Is your mic on? Thank you.
Where the 180-foot variance
Yeah,
is.
it was on my list.
The coastal wetlands is the area to the right there. That's a swamp over there on the right,
You
so,
want a pointer, sir?
yeah, I can't do it, I'm sorry, I have
No,
trouble.
no, okay, no problem.
There's a wetland on the right, there's water on the left, but on the right side, there's swamp over there, so
Yeah.
that must
Yep,
be the
I was up there.
180, that's, I was trying to figure out where that 180 square foot was,
Uh-huh.
linear foot was as well.
I'm sorry, is it 180 square feet, or is it 181 linear feet?
So it's a linear, sorry.
So it's 180 linear feet. Jill was just pointing out on the screen that 19.9 right here is the distance from the edge of the gazebo to the flagged coastal feature right here, CFA 2, CFA 1. And that 180-foot special use permit and variance is associated to the 200-foot coastal resource buffer, which is 200 feet. So it'd be 19.9 minus 200 feet, which is what they're asking for.
Got it. Thank you. And eliminating the gazebo will still require a variance and special use permit of some amount of something less than 180?
It would likely be a little bit smaller, but however, I believe the applicant's intent is to demolish the existing deck in totality. So they'd be asking for another special use permit and variance regardless of the gazebo or not.
Same order of magnitude, though?
Mhm.
Okay. And so the deck currently, if they were replacing the deck, they would not include an additional, any further variance in terms of linear feet?
If they're demolishing the deck in total, they would still need a variance
Got
and
it.
special use permit.
But if, for the same amount of?
It would likely be a slightly smaller variance. I don't know what the distance is.
No, I mean, the existing deck, let's just say it's at 170 feet right now from the coastal feature. If they tear down the existing deck, rebuild it with a new deck, will it still be 170 feet?
I'm not sure. I don't know.
Mr. Callahan, are you asking if the proposed deck is larger than the existing deck?
Yes.
Oh.
Mr. Howe?
It's just, the new deck will be just 4 feet wider.
Got it. So it's an additional 4 feet, linear feet, closer to the coastal feature. Got it.
Correct. That is the existing deck is all that dotted line stuff in front of the house. That 4-foot white line out front of that is the addition.
Okay. And can you tell me what hardship gets resolved by adding that 4 feet to the deck?
It's right outside the front door. There's a roof and an overhang there, and they have a table there with everybody has dinner there on the outside. It's only 12 feet wide, so it's a little tight there when people are walking by, when you got a dinner table, chairs on 2 sides like that. So this will give them another 4 feet. It's just making it a little wider.
Tom, you set?
I might have one more question. I'll read it.
No, you're well. Steve?
All right. First of all, great property. I took a look on our site visit. I think the gazebo would be awesome. Obviously, it's a big ask. The gazebo is a big ask. I like that they're willing to come back without the gazebo. Let me ask you a couple of questions. Where the new deck is going to go, that additional 4 feet What's there now? Is that coastal feature? Is it wetland
There's
buffer?
actually,
Is it?
If you stood at the edge of the deck and looked over, there's actually a set of railroad ties 4 feet off that railway stanchion, and that's a garden there.
All right.
So looking at that garden, that dirt that's there is not the original dirt from the original property. Somebody filled that in, because if you look under the deck, that dirt does not flow under the deck. It's basically, planting soil that
Okay.
somebody put there.
So, just so I'm clear, you're not proposing to do any more alterations of the existing wetlands there? You have a lawn in front of this?
There's a
It's just
lawn in front of
grass?
it too, yep.
Okay, and you mow and maintain that lawn?
Yep.
So this is not going to increase any, in your opinion, it's not going to increase any,
You're increasing the deck out to where those
Yeah.
railroad ties are, out to the edge of that flower bed, that's all you're doing.
okay, all right, nothing else.
So a couple questions I have. The 4 feet, how much of that is cantilevered off that outside beam?
We have 4 by 12 pressure-treated joists, 16 feet long, extended off the house.
Right?
I believe it's 4 foot.
So you're going to cantilever the 4 feet
Yeah, and
that
that's
you're
what they call-
overextending. So nothing's going to be, it's just going to sit over there cantilevered, nothing's going to be anchored to the ground.
Correct.
Okay. Could staff please put up the existing deck, please? No, the picture of the existing deck that was submitted in our folder. Do you have that?
That's to do.
It's an actual picture of the deck itself. It was in our folder. It was either in your...
Mr. Chairman, I don't believe we have it in the
Okay,
PowerPoint.
all right.
It's simply in your packet.
Yeah, so if you looked at the deck, it needs desperately to be replaced. I would be very happy if you were to agree to a modification and the removal of the gazebo and just the standing deck. Okay?
Okay, just had one more thing.
Yep.
I've been Mr. Asante's contractor for 5 or 6 years now. I spent almost 2 years remodeling that house, which was, to be honest, which was a rat trap. And if you look, I'm sure you know what the number on it is now. He's always just looking to improve his property and, look like all the other houses in the neighborhood.
Yep. Our scope goes beyond that a little bit. We got to look at the wetlands and everything else, and you know that. We're just looking at the big picture. But I'll tell you, if it would make it much easier if the agreement is that he forgoes the gazebo, goes with his new clean deck. I like the fact that it's going to be cantilevered and nothing's going to be in that 4 foot. So, do we have any neighbors? Anybody wants to speak on this? Doc, redirect.
No, I think we know where we're going.
Rupert? Tom?
There is a provision in the ordinance when you're dealing with a coastal feature and a variance and special use permit. And it says, in granting the variance in conjunction with a special use permit in the overlay district, the zoning board must make specific findings of fact defining any environmental features, which would be the coastal feature, to be protected in the manner in which granting the special use permit and variance will enhance the protection of the coastal feature, of the environmentally sensitive feature. So do you have any testimony or thoughts about how what you're proposing to do enhances the protection of the coastal feature?
As I said, I worked there for a couple of years. We ripped every shingle off that house and tore it down to the studs on the inside. We had silt fence all the way right across the front there, and that would be the project, we'd do again.
The language is interesting. It doesn't say mitigate, it doesn't say maintain, it says enhance. And I'm just wondering if you have any thoughts about how extending the deck by 4 feet, cantilevered, over this area would enhance the protection of the environmental feature.
I can't answer that, I don't know that.
Thank you.
Steve? Okay. All right. You want to add anything? Staff?
No questions.
Do I have a motion?
Sure. Move the application before us, Asante, Tax Assessor Plat W, Lot 77, is completed and in conformance with the town comprehensive plan.
Second that.
All those in favor?
Aye.
Unanimous? Do I have a motion on recommendation to the zoning board?
Yes. Move the application Asante Tax Assessor Plat W, Lot 77, positively with the staff's comments, recommendations as per the correspondence March 12, 2025, plus the agreed addition that the proposed, where is it here? The proposed gazebo area will be eliminated.
Do I have a second?
I'll second that.
All those in favor?
Aye.
Aye.
Any opposed? I have one nay. 4 carry, 1 nay. Good luck in zoning. Okay, so do you understand? Our recommendation is that in the positive to zoning, they still have to decide, but it's contingent on the removal of the gazebo. Okay.
Yep.
Good luck, sir.
Thank you all.
Thank you for your patience
Thanks.
tonight. Okay. I'm getting to you guys. All right. Bogden, Plat M, Lot 167-92, 9 Lane 2. And you got here early tonight, didn't you?
I did want to be a good doobie.
Yeah. Again, thank you for your patience. So,
Democracy in action.
Bogden, Tax Assessors Plat M, Lot 167-2. This is being reviewed under the 2023 zoning regulations. Lane 2, the applicant is submitting a request to demolish an existing one-story dwelling and construct a two-story, two-bedroom, single-family dwelling with a second-floor balcony at the above referenced property. The proposed project requires relief from the Breakwater Village Special District, Section 4.8.1.6D. The application is being reviewed under the amended Breakwater Village Special District Dimensional Regulations effective June 1, 2009. Existing conditions. Lot 167-92 is approximately 12,060 square feet in size and is located in the BWV Special Zoning District. Existing 20 by 20 one-story dwelling with an attached 12 by 4 outdoor shower. Existing building lot coverage is approximately 594 square feet, or 47%. Demolition of this is proposed. Demolition of existing dwelling and outdoor shower. Construction of a 22 by 23.5 irregular shaped two-bedroom, two-story, single-family dwelling with a second-floor balcony and an 8 by 4 outdoor shower. Proposed building and lot coverage will be approximately 506 square feet. That is reduced from 594 square feet to 40%, a drop of 7%. All right, the floor area ratio of this project is calculated at 0.58 or 737.5 square feet. A maximum of 0.60 or 756 square feet is permitted on this lot. So it comes in at a little less than 20 square feet under. All right. The project will require a special use permit under Section 4.8.16D Breakwater Village for construction of a two-story structure. Okay, elevation plans indicate the proposed building height is 23.8 feet. From average grade, 24 feet is allowed. All right, is on town water and sewer. And the proposed parking area is complied with Section 7.9 of zoning ordinance, 200 square foot per bedroom. The project proposes 400 square feet of on-site parking for a two-bedroom dwelling. Relief request, Section 4.8.1.6D, special conditions, special use permit for construction of a two-story structure. Reader's Digest version. Sir, if you can introduce yourself, what your role is, and tell us your story.
Good evening. My name is Derek Bogden. I'm the owner of this property. We purchased it around the start of the pandemic in 2020. We've got ties to the area. My daughter's enrolled at Prout. Go Crusaders. This is our happy place. This is where we go during the weekends during the summer, and we enjoy Breakwater Village as well as the Narragansett community, and hopefully, with luck, my daughter will be scooping ice cream down the road pretty soon. Ultimately, this is what we're trying to do. This existing property was built in 1940. It's up on cinder blocks. The floor is not insulated. There's electric radiator heat. If you look at the back setback, it's 1 foot or less on the back setback. When it comes to parking, the depth of my parking spot is 14 feet long, totaling around 336 square feet. And again, as articulated, the building covers 47%. And on the outside, it's all shingles. This is what we want to do. We want to tear this puppy down. We want to fix all the setbacks all the way around it to 5 feet. We want to make it energy efficient, which HVAC heating. I am not asking for 1 square inch of anything extra. We're going to increase the parking to over 200 square feet per parking spot to now be 419 square feet. That would be a 25% increase than what already exists. The HOA has already given me their approval, and from a procedural standpoint, my understanding is I'm just asking for the opportunity to build my second story. That's all I have to say. I think this is good for the environment. It's good to be energy efficient. It's good for the community. And then after it's all done, I guess my taxes go up. So it's good for the town too. I'll pause and see if there's any other questions.
We appreciate your civic duty. Doc?
Yeah, you mentioned not to prolong this because it's already late at night in my world. But all those places were up on cinder blocks when I came here. They were all just, people came down for the weekend, you know, the kids slept on the floor and whatever, but that was then. And this is now, and this board and the town work with the breakwater people to get to where we are today. And you're obviously upgrading the property and doing what you should do. Enjoy.
Thanks, sir. Yeah, I think it's a good project, good proposal. I appreciate you getting setbacks of 5 feet, which we understand from fire folks that they appreciate that. And yeah, I think the only reason you're before us is because of the requirement for a special use for a second story there. So,
yes, sir.
Tom?
I'm good.
Steve?
I'm good.
Yeah, I just want to add the same thing. I had a note. Just for people out there, if there's anybody listening, we try to keep setbacks to a minimum of 5 feet, and that is at the request of the fire department, trying to get their equipment, not just ladders and stuff, but the equipment they wear and stuff. And even at 5 feet, it's skinny. I applaud the project. I think it's going to be a betterment for the neighborhood. Do I have a motion on this?
Do you, people in the audience? You didn't
Oh,
ask
yeah, I'm sorry.
They don't want to come.
You guys want, they're like, no, we're not saying
No,
anything.
let's get going. All right.
You want to add anything?
Staff? No?
No further comments.
Legal, you want to
Okay.
add anything? Okay.
So-
Any redirect, because everybody said they had no questions, so I'm presuming no redirect. Okay.
So move the application before us, Bogden Tax Assessor Plat M, Lot 167-92 is complete and in conformance with the town comprehensive plan.
I second that.
All those in favor?
Aye.
All those opposed? All right, unanimous. Do I have a motion on the proposal and the recommendation?
Move the application before us, Bogden Tax Assessor Plat M, Lot 167-92, positively with the staff's comments and recommendations. You've read all of this, sir, right?
Yes, sir.
In the correspondence dated March 12th, 2025.
I second that.
All those in favor? Aye. We have a unanimous decision. Good luck. Thank you again. Thank you for your patience. All right. Fred Johnson's, oh, I'm only kidding. Knowles Camp. What's that?
Oh, these guys aren't Knowles.
Oh, you're not Knowles, you're the next guy. So nobody's here from Knowles? All right,
Oh, that's interesting.
that's interesting.
Yeah.
Staff, you want to reach out to them and find out what happened sometime? You know? All right. All right. Do we need to, like, continue them or anything, or we don't usually have this? Counsel?
No,
All right,
this
thank
isn't
you.
a public hearing.
All right, great. Okay, next up, Horeham, Tax Assessors Plat D, Lot 88-4, 16 Rockland Street. The applicant is submitting a request to construct a 28.5-foot by 28 one-story addition to include a family room and expand a master bedroom. This project requires a variance from the dimensional regulations. Previous application, the property has received the following Historic District Commission approvals. Historic Commission dated January 5, 2025, for the construction of a 28.5 by 28 one-story addition. Existing condition, lot 88-4 is approximately 8,320 square feet in size and is located in an R10 zoning district. Existing 46 by 37 single-family dwelling with an attached 32 by 2 by 24 by 2 rear yard deck, 4.5 by 4-foot outdoor shower, and an 18 by 10-foot detached garage. Existing building coverage is approximately 2,023 square feet and 24.3%. Construction of a 28.5 by 28 one-story addition on the south side of the dwelling. Proposed building lot coverage will be approximately 2,580 square feet or 31%. So let me see what other notes I had here. Elevation plans indicate the proposed building height to be 18 feet from average grade, 30 feet allowed, and seeking dimensional relief, 5.3% or 136.7 square foot lot coverage. Required amendment January 7th, 2025, Historic District decision. All previous conditions associated with these approvals continue to remain in effect. Hello there.
Good evening.
Could you introduce yourself and tell us your role and talk to us?
Absolutely. My name is Christian Infantolino. I'm the attorney representing Michael and Gail Horan, the owners, tonight. Thank you very much, first of all, everybody, for being here and spending all this time. I know you had some hiccups in the beginning, so I appreciate you staying to hear us out. Mark hit the nail on the head with the summary of the subject property. What I'm going to say is that the property, just for the record, the property is Plat D, Lot 88-4, does sit in an R10 district, and it's approximately 8,320 square feet. The percentages of lot coverage are why we're here today. Based on the undersized lot, the allowable lot coverage is 25.7%, and we're at, with the proposal, we'll be at 31%. The crux of this request is going to lie in the existing garage. The existing garage, as mentioned, is 18 by 10 feet. It's about 180 square feet, and it was considered by the Historic District, or the District Commission, to be historic and important to the property. So their approval, this project originally was presented without the garage. When they went to the Historic District Commission, it was stated that they really want the garage to stay. The Historic Commission loved the project, they loved the house, but it was contingent on the garage staying. So that puts us over approximately that 136 square feet by keeping the garage. The proposal, as mentioned, is roughly about 589 square feet. And it's a one-story addition. It's going to include a living and a main room. And the applicant and the architect, who I'll have here to describe the plans here momentarily, really took a lot of time and care to keep that cottage feel. They're not asking for a huge, massive expansion. It's a one-story level, increase the size of the family room and a master bedroom so he can live in there, and it would accommodate Michael's about to retire, and he wants to move here full-time and use this as their home, so it'll accommodate them moving here and living in place. So keeping the massing the one-story living area, and trying to be really reasonable with the request. Like I said, it's a 589 square foot addition, and if we were able to take away the garage, which he would love to do, I do have photos of the garage just so you guys can see the actual condition of it. We wouldn't need a variance, so.
If I also, I negligence to note this because I had like 14 stars here and I actually missed it, but staff notes that the hardship in which the applicant is seeking relief may be due to the unique characteristics of the structure. Both the dwelling and the garage are designated as contributing to historic structures built in the prior period, December 1949, within the regulated historic district. So I think that's important for us to have on the record and for the board to consider in all these conversations.
Absolutely, I appreciate that. So that's what I have for the introduction. What I'd like to do now is bring up Duncan Pendlebury. He's with Duncan Pendlebury AIA. He's the architect on the project, describe the plans, show you guys sort of what this addition is going to look like and what he's planned for the property.
I'm just going to set this right here, if that's okay. That's sketches showing what the house will look like as it faces the street. And as our attorney has mentioned, we're keeping it a single story, basically carrying the line of that roof that starts on the north side of the lot, carrying it straight across and trying to vary the elevation with a couple of little setbacks and things just to give it some interest and stay within the characteristics of the historic houses in the area. Now, we were backing up a little bit. The garage, we gave you some pictures there. It is in a little bit of distress. There's a tree that's been growing right next to it heartily, and it has started to lift the garage. The garage was never in our scope of work because we thought we would be losing the garage. And so if we lost the garage, we would not have a lot coverage issue. So we had a 188 square foot garage, which if it went away, that would easily take care of the 135 square feet that we need in addition, and that we're requesting here tonight. Backing up a little bit, when Mike first contacted me, the original house had a small bedroom, which you probably have seen in the plans, the master bedroom, and Mike and Gail were looking at this house as a retirement location. Since the time we've been working on it, which seems like a long time, Mike's family has expanded with grandchildren and so on. So the needs of the house are even more pressing at this point, as Mike will be spending all of his time here, and now the kids will be here as well. So we have proposed the 589 square foot addition, which includes a reasonably sized bedroom that you can actually fit bureaus in. The previous bedroom was one of those where you sort of had to dive across the bed to make it, because the walls were right up against the sides of the bed and there was no bureau space and so on. So we're looking for something that is livable, and that was the instruction I had to go with this. So the only dimensional variance is lot coverage. Everything else is in conformance. So we have the family room, which is where the old master bedroom used to be, and then we're putting a new bedroom on the outside of that and a bathroom, because there was only one bathroom in the house previously, so it'd be an en-suite bedroom. So, and the structure would all be on a crawl space, which is part of the house, and a lot of these cottages have crawl space anyway. So we're keeping the roof line in context with the original cottage and proceeding from from there. So that's where we're headed, that's what we're requesting.
May I?
Questions?
I was just going to say, yeah, if there were any questions.
Only question.
Doc?
Yeah. How many bedrooms in the house?
It's a two-bedroom house.
It's a two-bedroom house.
Yeah, we take away one
Yeah.
bedroom, put
Yeah, yeah.
another one back, so
Yeah, yeah.
it's still at two.
Gotcha. So you only have two bathrooms?
We have one bathroom
No,
now.
now, but
Now we would have
now you
two,
have
yes.
two bathrooms, okay. And what's the rationale, the Historic Commission, I respect them, but what's the rationale? This tree is growing into the structure. No, it's gonna destroy the structure, whether it's this year or next year. Were they able to express that? What's the rationale here?
We tried. We were a little taken aback because it's not going to be too many more springs before the garage is going to have to come down.
But it
probably.
destroys the usefulness because you're going to breach the structure, so storage becomes, because it has a little point on it? What is
It's
the thinking?
It's important to my client to keep the tree because it provides, it's a nice backyard. and
Oh,
it
no, the
provides
tree is
shade.
fine, but the garage, I don't, I understand, just looking at it, sort of looks old, but it's going to be destroyed gradually.
I don't think there is a rationale, to be honest with you, other than the fact that, you know, it was built in 1949.
Yeah, it was a long time ago, but it has,
It kept with the character of the.
but its usefulness is minimal, and I don't know what you could put in there beside maybe a Volkswagen Bug or something, you know? But in any case, yeah.
Dr. O'Neill, if I
Thank you.
can clarify, the commission has, like you have your planning board guidelines and standards, the Historic District Commission also has similar standards. And because the garage, that structure was built prior to the set date in the guidelines, which is 1949, I believe.
Yeah.
And the commission found that the preserving that historic artifact of that property was more important than the tree in that sense, and that the chairman also found that the garage had potential to be fixed. That was their
I'm sorry, the garage had what?
that the garage had potential to be fixed, repaired.
With the tree growing into it like that? Okay.
Point of information, and it has nothing to do with this, and I'm sorry we're getting sidetracked because these guys want to go home, but just my own curiosity and edification. Can they move the garage, or is that going to be a huge deal with this? It's got to stay right where it is.
It's got to stay where it is. They
That's-
share.
that speaks for itself.
The two properties together, they have very similar,
Yeah.
it's almost, they share a driveway. They're two very
Gotcha.
small garages right next to each other. If they move, I'm sure there's
All right.
setback issues.
I didn't want to hijack it, but I did, my curiosity got the best of me.
When we left the Historic District Commission last, the agreement was they liked the house, they liked the proposed addition, it fits for them, but at some point in the future, they want us to keep the garage and they want us to fix it at some point in the future.
Okay.
So, you know, assuming that we can fix it.
We'll see you again.
We'll fix it.
Okay. Rupert?
No questions.
Tom?
I'm good.
Steve? I'm good. Okay. Just from an architectural sense, I love the fact that you were able to blend the addition into the federal roof and keep that low line, because architecturally, that's not an easy thing to do. So I appreciate what you did in design. You guys want to add anything else? Anybody on redirect? No? Do I have a motion?
Sure. Move the application before us, Rand, Tax Assessor Plat D, Lot 88-4, is complete and in conformance with the town comprehensive plan.
I'll second that.
All those in favor? Anybody opposed? Unanimous decision. Good luck, guys.
No, wait.
Oh, I'm sorry.
Move the,
Trying to get you out quicker. I'm sorry. Just trying to help you out here.
move the application before us, Rand, Tax Assessor Plat D, Lot 88-4, positively with the staff's comments, recommendations, which you're aware of and you've reviewed, dated in the correspondence dated March 12, 2025.
I'd second that.
All those in favor? All those opposed? We have a unanimous decision. Thank you very much. Good luck, guys. Thank you very much. Thank you for your patience tonight. Appreciate it. Okay, approval of minutes. We have December, January, and February. Rupert, is this going to be long?
It's not. I did have a few tweaks, but they're little.
Okay.
If there's any length to them, postpone it till next meeting, you know?
That's what I'm asking. If this is going to be long, I'll postpone it.
Yeah, no, move the minutes of December 17.
Do I have a second?
Second.
All those opposed?
Tom?
All right. All those in favor?
Aye.
Anybody opposed? Okay.
Move.
Yep.
Move.
Hold on. One, yes, please. Yeah, it's going to be 4-0-1 in all of these.
Move.
All right.
Move the minutes of January 22nd with an amendment on page 1. The name for Mr. Brady, I believe, is not Marty, it's Mark.
Well, I've been called worse, usually by family.
And on page 2.
I'm sorry, where was the first one?
In the first motion, A1, elect Mark Brady. And then on page 2, in C1, second paragraph, just to clarify, it reads, Chairman Brady liked the scoring matrix included in the RFP and suggested the town council should complete the matrix. I think it should read, should complete the scoring of the applications according to the matrix.
Yes, the matrix is there. It just wasn't used.
And with those amendments, I move the minutes.
Do I have a second?
Second.
All those in favor? Okay. January 30th, 2025?
I move the amendment, the minutes as presented.
All right, do I have a second?
Second.
All those in favor?
Aye.
Okay.
And I move the minutes for February 19 as presented.
Okay.
Second.
All those in favor?
Aye.
Okay. All right. Reports from staff, liaison update, coastal access, we've not had a meeting yet. That'll be tomorrow night. I get to be here again. Under liaisons, and this will be taken up by the staff, I don't know what the procedure would be, but I've gotten feedback from a number of members on the board of trying to create a liaison with the affordable housing liaison, with affordable housing group, and what procedure, and I'm not asking to discuss this, I'm just thinking future business, what do we need to do procedurally to do that, okay? Priorities for planning board, final buckets, we have a list that Heidi submitted to us. I would ask that the board continue this to our next meeting.
So moved.
Do I have a second?
Second.
All those in favor?
Mr. Chairman, before you go, just on this one quickly, in order to move it along, it's come to my attention that Heidi told me earlier tonight that she misplaced or does not have the notes in which we went through the exercise to put these things in buckets. I'd be willing, happy to have somebody else be willing between now and the next meeting to bucket them and bring them as a draft for the board's consideration.
Thank you for
at the next
volunteering to
meeting.
do that.
I'm happy to do that.
So can we continue this until our next meeting? Do I have a motion on that?
So moved.
Seconded?
Second.
All those in favor?
Aye.
All right. Subdivision application submittal discussion. I'd also like to respectfully request that we have a continuance on this.
So moved.
Do we have to set a date? Do you want to do this tonight?
All I wanted to do, it will take 2 seconds,
All right.
honestly, because I'm not going to go through every single subdivision and what's happening.
Okay, thank you. I just figured that this might be lengthy, that's all.
No. It's
That's
just,
on me. I should have asked, and I didn't ask, and I just assumed. Sorry.
so I just wanted to give you an update. There are, I should have counted this, outside of our 14, I did count it. We have 14 right now. I, in some level of review, whether it's a minor subdivision with unified development, whether it's an administrative subdivision or a major subdivision, we have 14 subdivisions right now that are in some type of pending status. They're either waiting for sewer, they're coming back to you again because they just got out of they just wound out a legal, or they're waiting for some other piece of information. I have actually one that's active right now. I just wanted to mention on the record because it's a 5-lot subdivision. that doesn't require any relief. So as you may recall, the law changed in January 2024 that now allows, at this moment, allows subdivisions up to 9 lots. And if it doesn't need any relief, it doesn't need a road, or it doesn't need any other dimensional relief, it can be done administratively. It's required to be done administratively through the administrative officer. So you know, and everyone who may still be here virtually, I don't know if we have anyone, Ray, that we actually do have one 5-lot subdivision that's winding its way through. So I just want to let you guys know that it's at the corner of Kingstown Road and Lakewood. So you guys are aware. That's when earlier you had talked about what the changes are, and if we're starting to see them, we are starting to see them.
One of the things that we discussed when this all came down was that for total disclosure and transparency, that these administrative ones be brought before the committee. Obviously, people don't have to come in, you've made the decision, but that we vet it out in public.
I haven't made the decision, Mr. Chairman. The decision was made for us by the state.
No.
Oh, okay.
No.
All right, just so we're clear.
I know that. The review goes administrative, and we understand all that. But one of the things that we discussed, so that there's full disclosure and transparency, is that any of these, that you would come back and report it in the public so that the public knows what's going on, so that it's on the record. Nobody has to appear for us. Obviously, we're not making a decision. But one of the things that we had talked about was trying to create transparency. We don't want the perception that this is just background deals done. And that was a huge discussion by the board, and it was pretty vehement that we do some sort of disclosure on it. Now, how we procedurally do, I was just thinking it would be a report from the review staff. Or something.
Right, no, so tonight was just me letting you know where we are. So outside of the 14 amendments and the 4 pending ordinances you have and all of the other things, we have about 16, all in all, 16 with the comprehensive permits, or right down to admin subdivisions, are just lot line moves in our office. And that's not site reviews, that's not other stuff happening.
Right, and that's why I was letting everybody know this staff is drowning right now. So, Tom?
Just a quick question on that. The inclusionary zoning recommendation that we made to the town council that adjusted the threshold upon which one or more affordable units would be included?
Yes.
What's the status of that, and how
I've sent it to legal for their review and haven't heard back. So I don't want to put it forth to the town council until legal has vetted it.
Okay, and with respect to these things that are in the pipeline, would that provision not apply because these things have already started?
I'm sorry, which provision?
If the inclusionary zoning got adopted by the council, if it
Correct.
did, when it does, would it not apply to any of these applications that are in the pipeline that you've described because they were in the pipeline?
That's a legal question.
Good question, and personally being in the process of looking through it, let me get back to you on it.
Thank you.
Thank you.
Okay. Doc, anything closing? No? Rupert? Steve? No. Steve, welcome. Thank you. You got baptism by fire, bud. Sure. Okay. Good meeting. All right. Staff, anything you want to add? Council? Okay. Can I have a motion?
Move the meeting be closed.
It is non-debatable. My favorite, what's that? My favorite part of, do I have a vote? All those in favor of, all those? Thank you. Unanimous.